Madam, submission ಮಾಡ್ತೀನಿ ಸರ್.
ಚೇಂಜ್ ಮಾಡಿದ್ರು ಅದು ನಿಮಗೆ ಮುರಿದಿತ್ತು. ಹೇಳ್ಬಿಟ್ಟಿತ್ತು ಎಷ್ಟು ಮುರಿದು ಬಿಡ್ತಿತ್ತು ಮತ್ತೆ ಇನ್ನೊಂದು ತರ್ಸಿ ಹಾಕ್ಸಿದ್ರು. ಮೋಹನ್ ಕರಿಬೇಕು ನೋಡ್ರಿ ಮೇಡಮ್.
Give the list, all the memos to the court officer.
Page one, page number one, seal number 1, 2. Page number 2, seal number 3 to 5. Page number 3, seal number 6 to 10. Page number 4, seal number 11 to 13. Page number 5, seal number 14 to 18. Page number 6, seal number 19 to 23. Page number 7, seal number 24 to 28.
Seal number 25 and needful is done. I paid process today.
Non-depositing of amount of rupees 25 lakhs, 2.5 lakhs before this court as per the order. Which is it 25?
24.
24. Then counts for the petition submits that the needful is already done. This is matter after service of notice. Yes.
Please.
Yes.
Page number 8, seal number 29 to 32. Page number 9, seal number 33 to 40.
Seal number 34. It was listed yesterday. 40 parties intend to settle the dispute. May I request the Lordship may fix the date next week before the mediator so that we try to settle the matter.
What about the other side?
He had made submission.
Both the parties submit that there is a likelihood of settlement. Parties shall appear before the mediation center on 12th November.
Please.
Yes.
Please. 12.
Yes.
Page number 10, seal number 41 to 43.
42.
Yes.
Can you have it next week?
42.
Yes, sir.
Why next week?
I'm supposed to file affidavit. File next week.
Is it coming up? Yesterday, was it in the list? Have you informed the other side? At the request of the counsel for the petitioner, this is matter on 13th, no further adjournments.
Okay.
Well, it's serial number 43.
Yes.
I appeared for the petition minutes. I prayed for 3 days time minutes. There is a marriage function in my senior now.
Have you informed the other side?
Yes, minutes I have.
There's this matter on 13th of November at the request of land counsel for the petitioner. Yes.
Okay. Page number 11, seal number 44 to 49.
Number 49. Our petitioner husband, my lord, I produced the my lord, maintenance receipt, my lord. Can you next week one day, my lord?
No, non-filing of memo of acknowledgement for having deposited monthly maintenance as per the order
My
dated.
lord, my client, my lord, the inspection, my lord, next week one day, my lord.
It's a 2023 matter. Interim order might have been granted in 2021. No. We will see. We will see. That we can't accommodate like that. Yes, next.
Page number 12, seal number 50 to 53.
It's serial number 53. I prayed for 2 days the condition.
The same.
Same.
Yes. Inform the other side.
Party in person, ma'am.
Aisha.
Party in person, 53, ma'am. I'm not feeling well. Please give adjournment, ma'am. When I'm well, I'll come and put the.
No, she's asking. She's also asking for adjournment.
But not 2 days, ma'am. I'm having viral fever.
When do you want?
Just give it adjournment, when I'm well, I'll come and put the.
It's not like that. They should be.
4 weeks.
Why 4 weeks viral fever? We'll complete it. Let's this matter on 10th of December.
10th of this. Page number 13, seal number 54 to 64.
At the request of land counsel, there is small party in person. Yes.
Serial number 60.
60?
60. On behalf of petitioners, he is not keeping well. So may I request some proceeding for your lordship?
What will be there? It's a CP.
But he is not. I've informed.
I appear for the respondent. Respondent.
What is that?
I appear for the respondent.
It
may proceed on 13th.
This is matter on 13th at the request of land counsel petitioner. Interim order, if any, is extended. Yes, next.
Page number 14, seal number 65 to 77.
My lord, serial number 74, my lord.
74, yes.
My lord, all annexes are in Kannada language. I will produce the.
What are in Kannada language?
All additions.
We don't require energies for a writ petition.
I will produce.
Influent order is in English. That's fine. Tomorrow, we can come. Let the request of the inform the other side. Have you informed the other side? You will or you have? Tomorrow at the request of the council petition. This is 74 or 75? 74. Yes, next.
77 minutes.
Yes.
Friday. 77.
Friday.
On Friday.
You appear for the other side? Yes.
There is an interim order, my lords.
This is matter with the request of when council respondent on Friday. Interim order earlier granted is extended till then. Yes, next.
76.
76.
76. And for respondent, we'll have it on 13th or 12th.
Why?
But the petitioner, I am for respondent. Petitioner has performed the second marriage. I want to take instructions from my parties.
This is matter on 13th at the request of non-council respondent. Inform the petitioner.
Yes, I already.
Yes.
Serial number 7. Settled out of court. Serial number 7. Settled out of court.
It is submitted that already the matter is settled between the parties and nothing survives for consideration. Accordingly, the petition dismissed and instructions. Yes.
Page number 50, serial number 78, 88. Page number 60, serial number 89, 94.
Serial number 92 minutes. I am for the petitioner. I request for 2 weeks.
Right.
That's the reason is minutes. I have heard matter total number 3.
Go the entire day you will be arguing.
No.
Come,
I have
please
not-
come. Please do your work and come back.
No, I have not read.
You have not?
Read the.
No, that's a fair submission. Tomorrow.
No, tomorrow.
No. Will not adjourn 17 months.
Let's at least 2 days.
List this matter on Thursday.
Thursday, Monday.
No. See, all this, please don't make a mention and let the court not be embarrassed to reject your request for a adjournment.
Serial
Yes,
number
please.
90 minutes.
90?
90. I appeal for the petitioner. Must not have tomorrow or day after?
Tomorrow.
Tomorrow.
90 tomorrow at the request of non-council petitioner.
Page number 70, serial number 95 to 98.
96, my lord. Serial number 96. Pray for weeks time.
Why?
They have proposed some settlement.
Is it so?
Please.
It is submitted that there is a likelihood of settlement. List this matter on 13th of November. 13th.
15, my lord.
15th of November, no further time.
Please.
Whatever you want to do that by that time. Yes.
Page number 80, serial number 99.
Serial number 100, your lordship.
Hmm?
Serial number 100, your lordship.
Hmm.
Weeks accommodation, your lordship. Already I instructed. I had instructed the respondent counsel, your lordship.
You have instructed the respondent counsel what?
I will take the adjournment.
No, it's not about both of you agreeing. The court has to agree. No adjournment. Please come. Yes, next.
Because your lordship, the file is in the trial court advocate received as such, your lordship.
Then let inform the trial court advocate to come and argue.
Yes, sir. Yes, sir.
Tomorrow, no further adjournment. Yes, 100. Serial number? 1.
Serial number 1, password. Serial number 2.
My sincere apology. Yesterday's matter. I was on my legs in the other court.
So, at least ask him to come today. Yes.
Which I no, I'm doing.
You say about yesterday. Okay. Yes. Where is the other side? No, Mrs. SS Hegde for R1 and R2.
Son's marriage is there. Yesterday he has
Oh.
distributed the cards.
When is the marriage?
Date I'm not. Yesterday he was distributing the cards.
Dismiss this matter at the request of non-counsel respondent on 19th November.
Marriage is on
14th, 19th.
Seal number 3. GB9. GB9.
Your Lordship, we have already paid here.
Huh?
We have already paid to PR regarding respondent number 9 and 10. And legal lists of respondent number 1 are already on record as respondent number 2.
You filed a memo to that effect?
No. Yes.
You filed?
Yes, sir.
Where is that memo? Just look at it. A memo is filed stating that which respondent is this? Who died?
Respondent number 1.
Respondent number 1 died on 15/9/2018, and respondent number 2 to 8, who are the LRs of respondent number 1, are already on record. And the respondent number 9 and 10. No, it's not that. A memo is filed stating that the 2 to 8 are also LRs of respondent number 1 are already on record, and they will also implead they'll implead respondent number 9 and 10. It is submitted that already the notice is the prepaid process for issuance of notice to R9 and R10, post after service of notice. Yes, next.
Seal number 4. KL party.
Yes.
Yesterday's matter, my Lordship. 7-11D application is rejected. Lordship shall kindly take the plaint, my Lord, which is at page number.
What is the suit for?
Suit for partition, filed by the grand order.
You're saying that she is not in. Yes.
Yes.
Where is the order? Impugned order?
Lord, impugned order, your Lordship will get at page number 14.
40.
1-4.
40. Yes, please read the
Para
order.
4, your Lordship will get it. The present suit is filed by plaintiff for partition and separate possession. The mother of plaintiff died on 18/12/2006, leaving behind plaintiff as class 1 legal heir. It is submitted that suit property is ancestral Hindu joint family property of plaintiff and defendants and has been inherited by them from deceased depositor Sangappa. The plaintiff and defendants have been in actual possession, use, enjoyment of the suit property jointly. The names of defendant number 1 to 3 are jointly appearing in CTS extract of the suit property and trying to alienate and raising loans from different persons. Plaintiffs requested the defendant not to do the illegal act without affecting partition, but defendants have not aided to her request. Hence, present suit is filed. The suit property is valued at so and so. Then, my lords, after 3 or 4 lines, parties are as follows. The defendant number 1 is great grandmother. That sentence starts with it. Defendant number 1 is great grandmother of plaintiff. Defendant number 2 is grandmother of plaintiff. Defendant number 2 and 3 are daughter and son of defendant number 1. The mother of plaintiff died on 18/12/2006. Plaintiff is not co-personer, but she would be entitled to property inherited by her mother from her maternal side, as daughter is co-personer as that of the son and entitled for the share in property. The mother of plaintiff is no more. The mother of plaintiff is one of the co-personer in her father's family. The mother of plaintiff, being co-personer, would have all rights in the suit property and if she would have been alive, she would have inherited her share in the property from her family, and same would have been succeeded by the plaintiff as per section 15 of the Hindu Succession Act. And since mother of plaintiff is not alive, daughter has filed the suit seeking for partition and separate possession of the property to the extent of her mother's shares. If the mother of plaintiff, that is Sanjota, would have been alive, she would have been entitled to a definite share in the property from her family. And
Please
since,
come to the IA that is filed by you.
yes, my lord. IA, your lordship will get at page 23, affidavit page 24. Para 4, your lordship will get the relevant averment.
We'll read from para 3.
Please. I submit that the plaintiff has given wrong description of source properties and also wrongly shows the genealogy of the parties. One more sister by name Srimati Mangala, wife of Irappa Budihar, resident of Bableshwar Taluk, district Vijaypur, she has been given in marriage to said person Irappa, hence genealogy shown by plaintiff is utterly false and it becomes non-joinder of parties, hence suit of the plaintiff is deserves to be dismissed. Present maternal grandmother of plaintiff is grandmother of her and her father is alive who is her natural guardian. Has no right to act as guardian without due process of law. And one more thing is that defend number 2.
A week's time is granted for taking step within a week the needful shall be done, or else the petition shall stand dismissed without further reference to the court. Yes, next.
Seal number 5. Computation serial.
It's 2 days time again.
No, let's see this. 2022 CRP, RPFC.
Kindly taken tomorrow. Today. Because notes we are not getting the correct address.
Let's see first the impugned order. You have the file?
Yes.
Pass over. Please come, read the file and come. Yes, next.
File password. Seal number 6. Madan Mohan Kannu. Seal number 6.
No representation for dismissal tomorrow. Yes, next.
Seal number 7.
Milords, claim permission may be permitted to appear on behalf of the petitioner herein. Milords, this is the plaintiff's petition, Milords. Defendant had filed an application under 7 Rule 11 which was allowed. Milords, inadvertently, RFA ought to have been filed.
How can it be right from 2023?
Please. On the last occasion, Milords, there was a delay and the delay came to be condoned. Thereafter, Milords, I examined. If the application would have been rejected, Milords, then CRP would be maintainable.
That is a very basic.
Milords, please.
How can there be when a petition is allowed? How can you file a CRP and seek for conversion in 2024? Who will answer the 2 years delay?
Milords, bona fidely it was being prosecuted, Milords.
A bona fide mistake. And if the mistake, when 2022, it took for 2 years for you to rectify that. When was this memo filed?
Yesterday, Milords, yesterday.
Okay, now how you realize now?
That's what, Milords, on the
That's what it appears. Where is that proceeding sheet? And now it will go for another 10 years here. Office has also not taken any objection. Please come. The present revision is filed. Agreed with orders passed in I number 10 in OS number 109 of 2015 dated 20th day of April 2022. The petitioner herein is the plaintiff in the suit, and the respondent defendant had filed the I number 10 and orders 7 to 11. Rejection of the plaint as the same is filed, as the same is barred by limitation. The court, by order impugned, had allowed the IA and rejected the plaint. Against that order, dated 20th April 2022, a revision is filed before this court. On 1/8/2022, when the provisions were not complied with. Now, in 2024, a member is filed stating that they have not they have been they should have filed that states that instead of filing a regular appeal, they have filed this revision, hence permission may be granted to convert the same into a regular appeal. This court is not giving any, this court is not inclined to permit the petitioner to convert the same into RA. Right from the beginning till now, there appears to be a clear laches on the part of the petitioner in pursuing the matter. When the provision and is very clear, and the CPC clearly postulates that they need to be filed a first appeal against the rejection of a plaint. An order allowing the rejection of rejecting the plaint, filing a CRP in 2022, and now in 2024 seeking permission to convert. This court is not inclined to give the same. Accordingly, division is dismissed. Yes. Next.
Please.
Yes,
Husband has filed a petition. Husband has challenged the order of the trial court. The trial court has ordered 8,000.
There is a counsel for the petitioner. Password.
MS Matpati?
Is
The
there
last hearing date he has submitted that he has given NOC.
who?
And Matapati.
Sachin Siangdi?
But
Yes,
the
he was
court has
present.
directed to produce the notice.
Sachin Siangdi, submission Madi?
Serial number 8, Your Lordship, in pursuant to MS Matapati has filed the memo of retirement, Your Lordship.
Memo of retirement is filed by MS Matpati. It is stated that he has declared no objection or wakalat along with file and entire documents. He has also filed the letter addressed And also, and also the WhatsApp messages sent to the client, which are delivered to the client. Considering the same, the petitioner, the counsel is permitted to retire. Registry directed to print the name of the party and list this matter on 13th of November. Yes, next.
Okay. Bill number 9. Taken preliminary action.
That's, I have taken steps, Milas.
You already taken steps.
Taken steps, Milas, but postal Sara indicates that Milas, no such person in that address. I will take Milas fresh steps to new address.
How do you know?
Milas, I have ascertained by the Milas petitioner. Petitioner. She has given me.
For taking necessary steps, list is, a week's time is granted, same default order. Yes.
Obliged.
Bill number 10. Within CID. Within CID.
So dismissal tomorrow.
Your Lordship, week's accommodation for taking the steps, Your Lordship.
Week's time default order. Yes. Yes, next.
Bill number 11. Yes, part.
I do the needful during the course.
He submits that the neutral will be done during the course of the day. If the same is not done, the revision stands dismissed without further reference to the form. Yes.
Please, Lord, interim order granted earlier.
Interim order order granted is extended to
One more kind submission. As they are appeared, no need of servicing the other side, the trial court counsel. I'll pay the process with respect to serving. They already appeared before this court. There are two defects in respect of.
For all the respondents you are appealing?
No, my lord. Only in respect of respondent number 3, 2, 3, 5 to 10, my lord. We have appeared, my lord. And in respect of respondent number 4, they are not appearing, my lord.
With respect to respondent number 4 minutes, I'll pay the requisite process minute. With respect to filing of memo minutes, I need to serve the copy to the trial court advocate minute. Because they are appearing in the trial court with respect to other parties minutes. With respect to that minute, I'll pay 1 week time minutes.
So, as far as R4 is concerned, you are going to pay the process during the course of the
Please,
day.
Your Lordship.
Next, non-filing of acknowledgement for having served copy on the counsel appearing with the trial court as per the order dated 12/10/2023. What is that order? You that.
Honorable court.
What did the court say? 12/10/2023.
Also permitted to serve the correspondent to counsel appearing to respondent before the trial court. Last paragraph.
This court on 12/10/2023 has permitted the petitioner to serve the respondent through the counsel appearing for the respondent before the trial court and file proof of service within 2 weeks. Then counsel for the petitioner submits that already notice is served to R1. Our notice to R1 is held sufficient. R2, R3, R10.
5 to 10 minutes. 5 to 10.
R2, R3 and R5 to R10 are represented by the advocate. He submits that now only in respect of R4, he needs to pay the process which will be done during the course of the day. List this matter after service of notice to R2, and if the process is not paid during the course, the revision stands dismissed as far as R2 is concerned.
Interim order granted earlier.
Interim order granted earlier is extended till the next date of hearing. Yes, next.
I am for the petition in this case. We had instructed our client to pay the minimum half of the amount which is ordered by the court, Navila court. But he has not yet entertained us by not replying anything kindly.
Where is the interim order? Who appears for the respondents? They're all served.
R2 postage item below the address interacting with the client, but he is not responding to that.
We'll just vacate the interim order
Uh,
and let him come in his leisure time.
okay.
This court, by order dated 16/11/2023, I granted an interim order on the condition that
My lord,
the
1 week can we try to get?
finally on Monday.
Okay.
Police this matter on Monday for getting the instructions whether the interim order is complied with or not. Or else the order will be vacated on Monday. Yes. List on Monday. Yes.
During course of the day, we will carry out the amendment and filing of
Non-amendment of cause title as per the order dated 22/6. When you will do it today.
Yes, Minister.
List is mattered on Wednesday. By the time the needful shall be done, or else the petition shall be dismissed on that ground. Yes, next. Huh? A week's time default order. Yes, next.
Bill number 50,
Office has raised objection regarding maintainability of
What is this impute order?
my grievance is about the specific finding on issue number 3 by the trial court is in favor of petitioner. However, suit came to be dismissed. They filed regular appeal. In regular appeal, that finding of trial court is reversed. However, appeal is also dismissed. So both the court's judgment and decree are in favor of defendant. So I am unable to file the appeal. So I have filed the revision petition insofar as reversing the finding of trial court on issue of.
So like under which provision the revision is maintainable?
115.
Because you have no other level.
No, I can't file appeal because I have to file appeal under section 100. It should be against a decree. I am not aggrieved by decree or judgment. I am only aggrieved by the specific finding reversing the finding of trial court on issue of possession. So according to me, revision is maintained.
What do you say?
Revision is maintained.
Huh?
Revision is maintainable. In fact, this is third round of litigation. On merits, my lord, sir.
It is on merit. Wrong.
Revision, my lord, sir. Since no appeal on findings.
Because based on the modification of finding, now they have filed a fresh suit.
You are ready to argue the main revision itself?
If that objection is overruled and 3 and 4 are concerned for all notice is returned as unclaimed, it may be held sufficient.
I accept notice for other those.
R3 and R4 also. Let counsel for the respondent 1 and 5 submits that he has instructions to 5 Akalat in respect of R3 and R4 also. As far as the office objection with regard to maintainability of the revision is concerned, is overruled. List this matter on 19th November.
For admission. Yes, come for admission.
That day we'll hear it on it.
There is delay, my lord.
Delay is there. How much delay?
137 days.
IA number so and so is filed to condone the delay of 137 days for the reason. IA 1 of 23. For the reason stated in the accompanying affidavit, the delay is condoned. Yes.
Please.
Bill number 16. Speaker order.
This case, the wife has filed a recovery petition before the trial court, wherein both have settled their matter, and on 24th they have fixed a date for filing the compromise. After 24th, any
The
day,
counsel submits that before the trial court for filing the compromise memo. The matter is posted on 25th of November. List this matter on 28th.
Please.
Yes.
Bill number 17, Riverside. Dismissal Kamal.
My lord, submission. That name has been shown as Deshmukh Kamal. I have filed a wakalat that wrongly mentioned as Deshmukh Kamal. My name is Tejpal Kamal.
That right on appeal.
Yes, ma'am.
The name of the counsel. It is submitted with the counsel for the respondent that The name of the respondent, counsel is shown as so and so instead of so and so. D3 is directed to print the name so and so. What this you are seeking dispensation to R12 to R7.
Yes, no, there are co-defendants and we do not have any conflict of interest.
Memo is filed seeking dispensation of notice to R12 to R27. It is stated that there is no conflict of interest between revision petitioner and respondents number 11 to 27. Hence, the notice to the respondents were dispensed with. The memo is taken on record. A notice to respondent numbers 11 to 27 is dispensed with at the risk of appellant. Next.
Office objection on.
Office raised on wakalas filed by advocate for.
My lord, here the name of the respondent number 3 shown as in 2 times, respondent number 3 and respondent number 10. He is a GPA holder. I will comply with that.
Office objections.
Yes.
With
I
regard
request for time to file objections for I number 2, my lord.
Office objections. What do you want?
To file objections for.
I have requested for interim stay, my lord, if this can be taken up for admission and it can be disposed of.
Yes. Week's time I can give.
The respondent, counsel respondent shall comply with the office objections. List this matter for admission on 12th. Yes.
During the course of the day, I will take the first step.
Yes, same. During the course of the day, default order. Yes.
Number 90.
For dismissal tomorrow, no representation. Yes, next. For dismissal tomorrow, no representation. Yes, 20.
Number 20.
Same order. Same order.
Number 21. Approval of the party.
I will be permitted to withdraw the petition because husband and wife are living together.
The memo is filed stating that both the petitioner and the respondents have settled the disputes and have been living together. Hence, the petition was permitted to withdraw the petition. Memo is taken on record and the petition is permitted to, accordingly, the petition is dismissed as withdrawn. Yes. Next.
Yes, ma'am.
Number 22. ऐसा है?
Yes. For dismissal tomorrow, no representation.
Number 23. DM party. RM 11.
Petitioner. 2 weeks time.
Why 2 weeks time? Order is
Liabilities, asset and liabilities, it's agriculture issue.
No, order is passed on 26/2/2024. But why should we grant you time?
Just my order. It's week time, I will file.
Finally, a week's time. If it is not fair, decide it on merit. List this matter finally on 13th of November. No further time will be granted. And if the statement of assets and liabilities is not filed by both the parties, on that ground, the petition will be dismissed. Yes, next.
Number 24.
I think they made a mention in the morning. 24. That he has already furnished the PF and all. Yes, next.
Number 26.
No, not 25 urgent, 24 urgent. 25 is there. Yes, 25.
While writing entry for the procedural to directed me to the first
2.5 lakhs.
And on 29, 10, requested GD. On 29th, I went to file it to counter. Counter by request is saying that PAN card is required. Now, after obtaining PAN card, I tried yesterday.
It's deposited. Then we'll grant him permission to withdraw. We'll grant permission for him to withdraw. Withdraw the money. Then counsel for the petitioner submits that. that yesterday he has deposited the DD for an amount of rupees 2.5 lakhs before the registry. Learned counsel for the respondent, the respondent is permitted, not the learned counsel. Respondent is permitted to withdraw the said amount. List this matter on 19th November. Yes, interim order earlier granted is extended till then. Yes.
From beginning, I'm saying that I'm ready to take her back. Group petition. May I request to kindly refer to our parties for mediation. I'm ready to take her. There is an order for arrest, is a conditional.
Even both the parties, it is submitted with the learned counsel that there is a likelihood of settlement and he is ready to take the wife.
And still the conditional right is the order is there.
Even that we have challenged that order, my lord. The MSP is pending.
The list is, both the parties shall appear before the mediation on 19th of November. Yes. Next.
Number 26. Yes, something. Yes, something.
A week's time default order. Yes, next.
Number 27. Mauritius.
For dismissal tomorrow, no representation.
Number 28.
Respond number 2, we have filed an application for settlement 320. Parties are settled. They are present before the Honorable Court.
It is listed before.
There are two petitions, my lord.
CR to give the connect RPFC.
There are two petitions. One is RPFC and another 482 criminal petition. Both have connected. That's why, my lord, both the petitions.
Yes. No, what are the offences?
498 is the major offense.
What are the other offences?
No.
323 final for finance.
Let's see the where is that IA?
IA we have produced already.
1 of 24. Who are the accused?
Husband, mother-in-law, sister-in-law.
1 minute. Let me just look at the cost item. First petition is the husband. Second?
Second is father-in-law.
Third?
No, second one is mother-in-law, third is father-in-law. And fourth petitioner is sister-in-law. And fifth one is sister's husband and brother of the father-in-law. Sixth petition.
And what about this terms of the settlement?
My lords, they are going to withdraw the RPFC.
That is one aspect. That is that the return back all the ornaments.
Yes.
That's
and
already done.
Full and no.
What she said?
My lords, the MC petition is pending, divorce petition. On that 12th is the next date of hearing. Before that court, my lords, they agreed to return back all the ornaments.
Then why all these should be part of it?
My lords, that should be consent. No, sorry, sir. They are giving consent for the dissolution of marriage.
That's true. You know, you can't settle a matter which is going to happen on a future uncertain date, isn't it?
Please.
Any compromise, what you file there should be a full and final settlement with that.
As a full and final settlement.
You say that I have already received 4 bites when something is not happening as on today. Why should the court record all this?
No, agrees to return, my lords, not already returned.
Why should the court be a witness to all these future things? They agree to do that. If you don't do it, then what? Please file a memo on what is, as of now, what is complied with. That we will record, not all these things.
Even that could have been done, my lords. They have agreed and they will settle, return back before the MC court.
Then
That
you
can
do
be
that,
done.
you do that, you file your petition before that court, then we will do this, this order will pass at a later point of time. Why should first this be withdrawn? Why this be compounded on all these grounds, and what is going to happen at a subsequent date? No. You please do whatever you're supposed to do. Then finally we will quash this petition.
Pass over, ma'am.
Yes.
Please.
Pass over.
Number 29. Not there. Will not come.
Yesterday, in the first cycle, it appears that better affidavit is not filed. In fact, my brother has served.
Non-filing of better affidavit by advocate for petition.
My lord, yesterday, my lord, I filed the better affidavit, my lord.
Have you given a copy to
I
us?
have been served with a copy.
What is the delay? How much is the delay?
119 days delay, my lord, wherein I have filed objections regarding the earlier proceedings that have taken place between the parties.
You already filed your objection.
I have filed, for which your lordship had granted liberty for the petitioner to file a better
So
affidavit.
you want to file objections to that?
To look into the things and make a submission.
Land counsel for the petition submits that he has already he has filed the better affidavit, and land counsel for the respondent submits that he'll come up with his objections when.
And objections for submission only. So
When?
that
Yes, when?
next week any day.
He wants to get instructions. List this matter on 20th of November.
No, please.
Yes. Next matter.
Number 30.
Kindly pass on.
Don't have any instructions from the petitioner.
Why need to have instructions? You can argue the matter. The papers are with you.
What has happened is earlier counsel is elevated now. So we have not received wakalat and have not received any instructions from the petitioner. We do not have wakalat.
But we can't help it.
Please, notice may kindly be issued.
Any interim order is there in this? Then what will remain in this? A revision of 2016.
Only to save the business interest if notice is issued.
Then counsel, like along with him, who are there on record? On wakalat? Who are there? Look at the wakalat. Rajas Palloli. Did you get her? Issue registry is directed to issue. notice to the party, delete the name of the advocate and print the name of the party. Delete from the caption for dismissal.
Yesterday I was on BC, could not get connected with this matter. Matter with respect to an order passed by the work tribunal in a suit wherein declaratory rights were granted in favor of the respondent here, saying that the budget notification of the year 1968 is not binding on them, and as such they are entitled for a relief of a leniency against the board.
What is the remedy against an order passed by the Work Tribunal?
The CRP has to be filed.
No, there is some order, some judgment with regard to this?
83(9).
No, that is true. Some Justice Arvind Kumar's judgment, what is that? Something I have read on this?
I'll go through and make a submission as far as that aspect, what your lordship expressed. But the best of my understanding.
Something like some other order is passed. I think I've only seen in this bench, that order, earlier order.
I have to lay my hands over that, my lord. The lordship could grant some time. Ascertain that aspect.
List this matter from the delete this matter from the caption dismissal. List
Submission, lordship. I have sought a direction by filing an IA that I am running a high school in that trust property where 4 teachers have retired after superannuation. Now to appoint the new teachers to run the high school, the petitioners herein are objecting with the department of the government. Therefore, I have sought a direction.
Where is
because that? I number 1 of 23.
May I make a submission, my lord? Let my brother place it on record whether the board has made any education against the department.
Yes.
There is a lot of difference between contesting private parties and the board. What my senior brother is making a submission that the board has coming in the way of their appointment. That is not true.
No, until there is any order from this court restraining somebody from doing it, and you come up with an application, that we can understand. Now, if they are not doing, how can you seek an IA, file an IA in this?
The problem is, lordship.
Whatever is the problem, all your problems cannot be answered by this court.
Please.
No, any interim order is granted by this court.
No.
And in spite, without there being an order, if they are not doing, your remedy is not before this court.
My only thing is just they are posing this litigation before
For
department.
that, in a revision or filed by them,
Correct.
we can't pass any order because you are running the school. It's the respondents are required to do something. If you are not doing it, your remedy is under 226.
Please.
The list is matter on 13th of November. Finally, delete from the caption for dismissal.
Please.
Could it be 12, lordship? 12.
Huh?
In the regular,
I said delete from the caption for dismissal.
Please.
12.
Yes. Yes. See, is anybody online?
No.
The present petition is filed. Agreed with the orders passed in I number 3 in MC number 170 of 2019, dated 9th January 2020. Whereby the husband is directed to pay interim maintenance of an amount of ₹20,000 per month to the wife from the date of filing of the petition till the disposal of the case. And this matter came up on 4/11/2024. As there was no representation on behalf of the petitioner, this court had directed the matter to be listed on the caption for dismissal today. Today also there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to pursue the matter. Accordingly, the writ petition is dismissed for non-prosecution. Next. What is this PF paid at last hours?
Sorry, yesterday I was in quota number 9.
The delete from the caption for dismissal. As per the office note, PF is already paid. List after service of notice.
Please, ma'am.
Yes. Yes.
Nagesh Raibhai, Ganesh Raibhai.
About the petitioner,
Huh?
petitioner.
Yes.
The petitioner number 1 is wife and 2 and 3 are the children. The maintenance petition, the dismissal of the ground of the petitioners have not produced any documentary evidence or corroborative evidence in the proof of the respondent assaulting abusing.
How much maintenance you have claimed?
15,000. 15,000.
15,000. And what is the respondent according to you?
He is came from welfare company.
Huh?
Welfare company. He is from. And as sufficient replacement also. 4 acre irrigated land and.
Has he appeared before the court? Respondent appeared before the court?
Yes, yes, please.
Inform the respondent counsel. We'll take up in the afternoon. Yes, pass over.
DV Patta. DV Patta.
This is a petition of the year 2023. The petitioner has not complied with the office objections even till now. On 21/10/2024, this court has passed an order. If the objections are not complied with by 24/10/2024, places a matter under the caption dismissal on 24/10/2024. On 24/10/2024 also, there's no, the office objections are not complied with. Hence, directed the matter to be listed on 4/11/2024. On 4/11/2024 also, there is no representation on behalf of the petitioner. Hence, directed the matter to be listed on the caption for dismissal on 5/11/2024. Today, when the matter is called, today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
For the petitioner. The petitioner had filed a petition for writ of certiorari crossing annexure J method. In annexure J, I had in annexure G is the FIA that I had, the petitioner has filed before the family court, wherein the custody of the child was sought with police protection. The same was rejected. And the purpose of filing this particular annexure G was because the present petitioner has secured a JLW order in his favor, wherein custody was supposed to be given to him from the respondent. But subsequently, even an I was filed, and both the bailiff was also appointed. When the board bailiff has gone to the village and in order to give the custody to the petitioner, the respondent has created hue and cry, and the giving of custody was obstructed. Subsequently, he has filed this particular I. Even during the previous hearings before this honorable court, mediation was done before by the predecessor.
No. On what ground your application is dismissed by the court?
Saying that the child cannot be given in custody by the police because the child's will be with the father.
Has she questioned that order of granting custody?
No, she has not questioned as
She has already filed MFA, Your Lordship.
Any interim order is granted?
Yes, there is a stay order, Your Lordship. Division bench. So this writ petition, they can appeal this order there. This writ petition.
Give that order copy.
Please.
The present petition is filed. Where is the impugned order?
Impugned order at annexure J, my lords, page number 124, my lords, 123 to 125.
Present petition is filed. Agreed with the orders passed by the trial court in EX number 3 of 2022, where an application is filed with the, you are the husband or wife?
I am the husband.
Huh?
I am the husband.
Filed by the husband under section 151 CPC with the prayer to direct the police to give protection to the process server so as to hand over the custody of the minor child to the decree holder. It's a case of the husband that he had an order in his favor in GNWC number 1 of 2021, wherein the custody was granted to the father. It is the grievance that, in spite of an order passed by the court, the mother had failed to hand over the custody. As such, he has come up with this application. To that, the wife had filed objection, or the mother has filed objection, that the application is not maintainable, and the father cannot take the custody of the minor child through police aid, and such order cannot be passed. The trial court, by order impugned, had dismissed the petition, observing that there is no provision provided for securing the presence of minor child, that too give the child using police protection, because in such cases the interest of the minor and welfare of the child is very important. And already the court had directed the process server of the court to take assistance of lady advocate and to secure the child. The report was filed by the process server that the mother of the child refused to hand over the custody, and even the child has expressed its willingness to stay with the mother, but refused to go with the father. And in those circumstances, the prayer made by the decree holder, father, to direct the police to provide him assistance and to take custody of the child is not at all provided under any provisions of the law. And it's a fit case, and it's not a fit case to direct the police to hand over the custody of the child, or for the police to interfere between the DHR and JDR to secure the child, and accordingly dismiss the petition. Next para. When counsel appearing to the petitioner father submits that when he has an order in his favor wherein the custody is granted to the mother is granted to the father, the mother is bound to give the custody of the child to the father. When the decree is not honored by when the order is not honored by the mother, it's the duty of the court to take appropriate steps and to see that the decree is executed. He submits that without considering all this, the court had dismissed the application. Next para. When counsel appearing for the mother submits that agreed by the orders passed in GNWC, wherein the custody was granted to the father, she had filed MFI number 103891 of 2023, and by order dated 25th September 2023, the court had granted stay of the impugned judgment and the decree dated 21/2022. Learned counsel submits that as the MFA is filed and the order that is granted by the order of the granting of the custody itself is stayed by the court. Nothing survives to be survives in this writ petition. Having heard the counsels on either side, there is a material on record. Petitioner filed a the impugned order is filed. Impugned order is question which is passed in the EP proceedings. Now the main order itself is stayed by this court, and as rightly pointed out within an counsel for the respondent, nothing survives from consideration in this petition. All the grounds that are available to the petitioner is always at liberty to agitate before the agitate in the pending MFA. In that view of the matter, the petition, the present writ petition is dismissed.
To proxy counsel, my lords. Personal inconvenience to counsel on record. Kindly matter must be taken. Weeks accommodation may kindly be granted.
5 years not there yesterday.
Counsel, he is out of town, my lords.
Then you should have made some arrangements for that.
May kindly be taken on Monday or Tuesday.
You have not filed the PF till now. Ask him to do it. Delete from the caption for dismissal. The petitioner shall pay the process within a period of 1 week, or else the petition shall stand dismissed without further reference to the court. Yes, 40.
Number 40. The petition in this case, my lord, the husband and wife are disputing, my lord. They are responding to the divorce wife of the petitioner. In all the petitioners earlier before this court, on the same address the notice has been served. But in this case, now it has come as insufficient address. The petition is arising out of criminal petition. In the criminal petition also she has given the address which is shown in the cost item. But here now it has been shown.
The criminal petition is pending.
Subsequently it is disposed, my lord, after filing of this petition. But the address is the one and the same. And even she has filed the affidavit before the Honorable Supreme Court in which of
As far as insufficient address is concerned, that is not something the respondent will do. It's for the postal people who have given that endorsement.
This is managed by the respondent, my lord. Because I am ready to pay the process fee once again, my lord. But what is happening is here is intentionally they are trying to dodge the proceedings. I inquired with my party whether she had changed the address or not. He said she is staying at the same address. I have made those documents to the annexes.
The lead counsel for the petitioner submits that already in the criminal petition. And in what is other proceedings?
Criminal petition 101977 of 21. Before this
101977 of 21, the very same address is furnished. And now when the notice is taken on the same address, it is returned as insufficient address. He submits that he'll pay the process. And as per his instructions, she is staying in the very same address. The petitioner shall pay the process within a week and shall issue the notice on the very same address.
Please, madam.
Please next. Post after service of notice.
Admission number 41.
VC.
I appear for the respondents, my lord.
Yes. May I seek it next week, since your lordship, the petitioner before this honorable court is now in custody from last 10 days. Will seek instruction. Otherwise, I'll withdraw this petition. So further, I am seeking 1 week.
2019 CRP.
That is what your lordship will withdraw in the next week. Otherwise, the party is not communicating.
Finally, this is matter on 12th of November.
Yes.
No further time will be granted.
Yes.
At the request of one counsel, the petitioner, delete from the caption for dismissal. No, it's an admission. It's an admission.
Yes, my lord.
This is matter on 12th. No further adjournment.
Yes.
Yes.
Number 44. Number 44.
For petitioner. This petition is
Non-filing of memo for having deposited 50% of the maintenance as per the order dated 7/3/2023.
Because he is earning as a lecturer in JSS college.
No. Is it 44?
Yes, 40.
So where interim order is granted, have you deposited the money as per the order?
Senior is out of station. Can you have it on mail?
This is in 2023. You should have filed a memo by this time.
He's out of station.
List this matter on 13th November. By the time if the memo is not filed, the petition shall stand dismissed without further reference to the court. Yes, 45.
Petition by the wife and daughter.
How much is the maintenance granted?
3,000 to the wife and 2,000 to the daughter.
3,000 to the wife and
2,000 to the daughter.
5,000 is granted. What is the husband's income?
Income, my lords, we produce and also they also produce at the time of before retirement 55,000. Now after retirement he is getting 27,000, including DA and this one.
He retired.
Retired.
What is the age of the child?
Child now age 17 years. She is studying in first year degree. BC.
What do you say?
See what happens? Earlier, the respondent was working. Now he has retired, and he is getting 17,247. And moreover, the respondent is physically handicapped. He can't live alone. He needs a maid throughout his life. Nobody is there to look after him.
What is the nature of his disability?
He can't. He is so worship. He is completely disabled person. He needs a person. So we have to take into consideration that also. Nobody is there in the home to look after him. Moreover, worship.
Divorce is granted?
No. He filed that has been dismissed. Now he has preferred MFA before the dismissal.
But what happens? Our settlement, one-time settlement, 50% amount of the Hana Lasha, but 50% amount we have offered for 50% amount. They have not agreed. And then now what happens? He can't.
What is the settlement you have offered?
Either amount, pension amount, total comes 11 lakh and all. He said to give 50% of the pension amount, but they have not agreed for that also.
That is 11 lakhs means you are ready to give how much?
Other 50% of the amount.
Then what else you require?
No, very. Huh? He requested to enter our name in the service records. He didn't enter.
No.
Who is pending for the same?
Wait.
He says that they are ready to give half of the amount.
Of my lords, I asked my parties.
Please get instructions because definitely you will not get any relief in this case. Because from a physically handicapped person.
He is a government school teacher. He served more than 50 years. He was not now.
He retired.
He served more than 25 years.
We are on the monthly income.
Please.
And now he is getting 17. He is getting 17,000. Code is already
27,000 per month, my lord.
No.
I am having a document. So that
Why government has given two different kind of proposals for both of you?
No, it's
it should be one and the same.
pension relief order.
Both, take both.
And we see the document now I produced, dated on 18th April 2024, my document. In the second page, my last column, part 6. Very on monthly 2024, that is 17,247. In addition to that, on 31st 5 2024, DA 7,330. IR 2,930. That is to be added 17,000. How much he is getting the pension per month?
What is IR?
IR means
इंटरमीडिएट यानी उसको पेमेंट करने सकते हैं तो ये कितना थोड़ा परसेंटेज पेमेंट करते हैं
एवरी मंथ आता है
कभी कर सकते
कभी होता है तो फिर वो कैसे ऐड करेंगे तो 17,247 है No, even on, you can't expect him to pay anything more. Please, please put a word to your client. If she is happy with that, half of that, let's put you can file a memo before the court.
I will ask my party.
That's what, put a word to her.
Please.
Then counsel for the respondent submits that the respondent is ready to give 50% of the pension, the retirement benefits, which are the retirement benefits are 11 lakhs and all. He is ready to give 50% of the amount and to settle all the and to have a full and final settlement. Then counsel for the petitioner submits that he'll get instructions from his client from his client. This matter on 20th 20th November. That papers, no, give it to them. Take those papers. Both give it to them.
The matter is settled, my lords. The parties are deciding together. There was a decree of divorce which was obtained by the petitioner. Now that is being set aside by the district court, Andhra Pradesh, Vijayawada. The parties are deciding separately. Any date after 23rd, my lords, we will file a settlement.
After 23rd, any date?
It is submitted that both the parties are residing together. The disputes are resolved, and they'll come up with an appropriate application before this court. This matter on 28th of November.
Please.
Yes.
Number 47, Shivashu, DA
There is a possibility of settlement, madam. This is the petition of White's.
Not about to mediation, right?
You're before the mediation now.
Please.
When is it coming up before the mediator?
No, madam. It has to refer.
It has to be referred now. It is submitted that there is a scope for settlement. Both the parties are directed to appear before the mediation center on 13th of November.
Please.
Yes, next.
Number 48.
I appear for respondent.
No representation for the petitioner. Counsel for the respondent is present. List for dismissal tomorrow.
Number 49. Arun Kumar Kulkarni.
Why?
The counsel for the petitioner will submit some relevant documents.
Not relevant documents. Non-filing of memo of acknowledgement for having deposited monthly maintenance as per order dated 12/9/2024. 2 weeks time. You have to file the memo. You having taken an interim order on 12/9/2024. If you don't file the acknowledgement, what is to be done? We'll have it on Monday. By the time you have to file, by Monday the acknowledgement has to be filed, or else the interim order will be vacated. Yes, list is part of 11. Yes.
Number 50. By Kopesh, DSLP.
Please, I am for the respondent, my lord. The petitioner is running.
Mediation is not successful. Mediation not successful.
Not successful.
Not pressing IA2 of 23 for stay. Non-filing of memo of calculation by the counsel for respondent. Have you filed the memo of calculation?
Yes, sir.
When did you file?
A week's time I can leave it.
Where is the counsel for the petitioner? Counsel for the respondent is present. No representation for the petitioner. List this matter tomorrow for dismissal. Yes, next.
Cell number 51. A party, A Pata.
13,000 is awarded.
How much is awarded?
13,000.
1-3.
Yes, sir. And at the time of obtaining the interim order, it directed me to deposit 10,000 per month. And depositing it in today.
Madam, kindly pass on, madam.
Pass it, please.
51 password. Number 50. Send Banta.
It may carry with password, my lord.
Pastor.
We are done. 54. Cell number 54.
No representation. How's this matter for dismissal tomorrow?
Number 55.
Appear for the petitioner, most petitioner is the wife, the respondent is the husband.
What are these two petitions?
One is MC, first petition was MC 7 of 24 have seeking for transfer now. MC 7 of 24 is filed for.
1 minute, let me just look at the prayer. Give the next file also. Now, withdraw MC number Badal Court to Vijaypur. How much, what is the distance between the two?
86 to 90 kilometers.
And what is this?
In first petition I have chosen.
The second.
Second is MC 69 of 24 minutes, where the husband is filed for divorce.
What is the first MC?
For restitution of conjugal rights.
Both filed by him.
Please.
How can he file both at a time?
When I am taking the stay and after that he is another one is filed.
But he can't have both. He can't have a restitution and he can't have the divorce both. How can it be? Strange. Yes, please come. CP 1000065 of 24. And the present petition is filed. CP transfer of MC number 69 of 10065. Seeking transfer of MC number 7 of 2024, filed by the husband seeking divorce, pending on the file of the Principal Judge Family Court, Badal Court, and transfer the same to the Principal Judge Family Court, Vijaypur. The facts of the case are that the marriage had taken place on 29/4/2021 at Vijaypura. And out of the wedlock, they're blessed with a boy on 6/10/2022. It is the case of the wife that in the month of August 2023, she was knocked out of the house and the wife had filed criminal miscellaneous number 583 of 2023 for maintenance, which is pending before the Principal Judge Family Court, Vijaypur. It is the case of the wife that the distance between both the places is 70 kilometers. 86 kilometers. 86 kilometers. And she is depending on a aged widowed mother. She is not having any source of income. And it's very difficult for her to travel on every date of hearing with her 1-year baby. Hence, she sought for transfer. Though notice is served on the respondent, there is no wakalat is filed on behalf of the respondent. Having heard the learned counsel for the petitioner, there is entire material on record. Considering the facts that already a petition seeking maintenance is pending before the court at Vijaypura, and also considering the fact that she is having a small baby to take care of, and also the financial constraints that are placed before the court, this court deems it appropriate to allow this petition. Accordingly, the following: the MC number 7 of 2024, pending on the file of the Principal Judge Family Court, Badal Court, is withdrawn and transferred to the Principal Judge Family Court, Vijaypura. Next matter, that's 1001 of, no, you take the one because it is same facts. Next matter 100194. This is only facts are one and the same. It's only petition is filed under seeking transfer of MC number 69 of 2024 filed by the husband under section 9 of the Hindu Marriage Act from Bagalkot to Vijaypura. Same, remaining facts are same.
MC number 69 of 24 is filed for divorce.
Huh?
For divorce. MC
69 is under section 9 of the Hindu Marriage Act. Please look at your prayer. Page number 8, 100194. Page number 8 of your FF. MC 16, na?
69. 69.
I said 69 only.
Please.
Yes. Hello.
Hello.
Same facts, only the MC numbers will change. Yes.
This, I seeking transfer of petition filed by husband at Bangalore family court to Bagalkot family court.
Distance?
This is 500 kilometers. Wherein she filed for divorce.
MC is of which year?
24. Both are of year 2024. Wherein she filed for divorce and he filed for restitution of conjugal.
No. Husband filed for?
Restitution of conjugal.
At Bangalore. That
At
is
Bangalore.
that she is seeking it to be transferred to Bagalkot.
Wherein she initiated for divorce.
Oh, it's already pending. Please come. The present petition is filed, seeking transfer of MC number 894 of 2024, pending on the file of the Principal Judge Family Court, Bangalore, the Principal Judge Family Court at Bagalkot, where the MC filed by the wife seeking divorce is pending consideration.
My name is Shashidhar ma'am, 56 my case number. I come from Bangalore. Yesterday only I come to know hearing is there. I'm not in Bangalore the frost from 1 month like that. So I couldn't get the issues. Yesterday I gone to court, yesterday civil court. Judge only she told that your case is in Dharwad. So
What happens is, when wives file a petition, now you engaging an advocate is also an unnecessary effort. Ultimately, her petition will be allowed. Because already the divorce petition is pending in Bagalkot.
Okay, and then
So that will be transferred from there to here. And you have to appear here.
So I have to fight in Dharwad only, right?
Not Dharwad. What is filed at Bangalore will be transferred to the that court in Bagalkot, where divorce proceedings are pending. So you can appear in that court. What did you write? Tell him, no? Tell him what is. What I told him, you just tell him, no?
Thank you.
Oh, what did you write? Pending consideration. The brief facts of the case are that you could have let him stay here. You could have heard what has been.
I told him that to stay.
He didn't understand. Ask him to come and stand. It's okay. The brief facts of the case are the marriage had taken place on 3/6/2013 at Hubli. The husband is a resident of Hubli and working in Bangalore.
I'm having a child. I am raising her. I am looking up her. So I couldn't travel from Bangalore to here. For that only.
Child is with you?
With me only, and she is working there only.
In Bangalore.
She is irritated. Means she is giving a tough to me. Means.
You can engage the advocate, or you want a counsel from the legal aid.
I want to engage the I want to hire the lawyer, but I want to in Bangalore. But I can't.
No, whatever you want to tell, you can file all your objections so that the court will understand. When you are saying that the wife is working in Bangalore, you must be having something.
Yes.
All that you have to put in a form of objections.
Okay.
Then we'll adjourn this matter. You engage an advocate.
Okay.
The notice to the respondent husband is held sufficient by this court. Today, while the court is going to dispose of the matter, he has appeared in person before the court and submits that he'll engage the advocate and seek some time. List this matter when? List this matter on 26th of November. By the time he shall engage the advocate and shall file necessary objections, or else, basing on the material, the orders will be passed. Yes.
This petition will not be the petitioner has challenged. The order passed by the trial court on item number 3. In a suit filed by the respondents.
Item number 3 is filed under
order 7-11 A and B of the CPC for rejection of the plea.
What is the suit for?
Suit for declaration, injunction, and alternative prayer for possession of the suit property.
Recovery of possession.
Recovery of.
And on what ground you say that is barred by limitation?
Barred by limitation is that the respondent's plaintiffs are disputing the increase in the name of the petitioner hearing in the year 2010-11 and in the name of Lakshmava Malad, the president of this respondent.
Now please come to the IA.
Please.
That's filed by you. What are the grounds?
Page number 52 minutes.
52. This is in Kannada. Because unless and until the court understands what it is, then can you find a translated copy of this? When? Day after tomorrow?
Weeks.
A week's time. List this matter on both the matters? In both the matters, same.
No, only one.
Oh, next is not yours. Yes. List this matter on 14th November. 14th November. By the time the translated copy of the affidavit in support of the IA shall be placed before the court. Yes, next.
Number 15.
This is the petition filed by the Bank of Baroda Gangavati Bank, challenging the order on preliminary issue regarding the maintainability of the suit filed by the plaintiff, my lord. Respondent hearing. Suit was for specific performance, my lord. He is the auction purchaser, my lord. Sale certificate was issued in the year 2015, my lord.
No. What suits for specific performance?
Yes, my lord.
Who is the auction purchaser?
Plaintiff, my lord. Respondent hearing, my lord. He has purchased through auction, my lord. And
so through bank auction?
Through bank, e-auction. And sale certificate was issued in the year 2015, my lord. 18/6/2015, my lord.
18/6?
2015. And he has given acknowledgement to having issued all the documents on 16/6/2015, my lord. Up to 2019, he kept quiet, my lord. Thereafter, he files a suit, my lord, for seeking for specific performance of contract with the prayer to
against the bank.
Bank, my lord. The prayer, my lord.
What's the difficulty to you? He's an auction purchaser.
Yes, my
you
lord.
sold the property.
We have given all the original documents to him in the year 2016 only, my lord. He has not made any efforts up to 4 years. Thereafter, my lord, he filed his suit, my lord.
No, but ultimately, he paid you the money.
Yes, we are not disputing that. We are not disputing.
So what is
the preliminary issue regarding the maintainability of suit in view of the bar under section 34 of the Surface Act. That application.
No, he is not a defaulter.
Yes, he is not defaulter.
No, it is such a simple issue. No, you have sold the property to him.
Yes, ma'am.
And according to him, you have not executed the documents, relevant documents. That's the only thing that what he is seeking is that. Why a suit and
My lord,
being a bank?
because, my lord, as per the Surface Act, my lord, there is a provision for non-exempting from bank authorities to appear before the sub-register, my lord. When he had been to sub-register, he came to know that, my lord, the original borrower had sold the property, my lord, according to him, my lord. But the original documents are with the bank, my lord, and we have handed over the original documents to him. After verifying the documents, he has purchased the property through auction, my lord.
So a poor person who has purchased a property from you, and now you say that the suit itself is not maintainable. You are not going to lose anything out of it.
But, my lord, now the claim of the plaintiff is that, my lord, earlier to the auction sale, my lord, the original borrower had sold the suit property.
And then what is he supposed to do?
My lord, actually he has to make an subsequent purchase of, my lord, as a proper party, my lord, and also the sub-register, my lord. Because when the original documents are with the bank, my lord, they have...
No, under the Surface Act, you sell the property to a auction purchaser, and by the time you sold the property, already the sale had taken place, and you don't even bother about it. Then what this person has
No, original documents are with the bank, my lord.
Whatever it is, no, the sale had taken place. You didn't even look into it. No, when somebody is purchasing the property, they'll be in the confidence that they're purchasing from the bank. No, by the time you sold the property, already that property is sold to somebody else.
Because, my lord, the original sale documents are with the bank, my
No,
lord.
whatever it is,
the
sale
plaintiff has
place.
verified all the documents, my lord. Now he came with the case that, my lord, the original borrower already sold the property, my lord.
No, that is a fact which is born out of the record. You also cannot deny it. If a transaction has taken place, and in the registrar's office there would be an entry with regard to the same, which is much prior to your auction.
Earlier, what happens, my lord, there was no registered mortgage deed created by the bank, my lord. Only my deposit of title deeds, my lord.
Then pay back his money and fight with the owner of the property, with the original borrower. That's your responsibility to take care of all the legal this thing. Happily, you take money and you give the burden to the third party.
In this challenge is that, my lord, in view of the section 34, my lord, it is the only...
That is surface, like, no, where are the surface proceedings? There are no surface proceedings. Everything is concluded. No, you are as good as any other vendor. Is it not? Well, dismissal. Please come.
The order is that, my lord, suit is maintainable before the civil court.
Yes. Rightly, counsel, the plaintiff has vehemently argued that plaintiff is neither borrower nor creditor under the Surface Act.
That is true, ma'am. That is not true.
And it is concluded. Everything is concluded. Now you stand.
My only submission is that, my lord, he kept it for 4 years, my lord. Has
No,
not
for
made
that,
any efforts.
that's a mixed question of fact and law, which will be decided if you say
At
that.
least he could have brought it not to the notice of the bank, my lord, so that he could have made any...
He shouldn't have bought the property from a bank auction. The present petition is filed. The present revision is filed. Agreed with orders passed on the preliminary issue on the maintainability of the suit. The respondent plaintiff had filed the suit for specific performance of where do you get the plaint?
Sorry, not this.
No, please pass on. Has filed the suit seeking specific performance and directing the bank to execute the registered sale deed of the suit property in favor of the plaintiff within a specified period, and in case of failure of the defendant to do so, the court may be pleased to execute the registered sale deed in favor of the plaintiff, and also sought for the delivery of possession of the suit property in favor of the plaintiff, and in the alternative, the defendant may be directed to refund the earnest money of rupees 9,95,550 to the plaintiff, together with interest at 12% per annum from 26/8/2019 till the date of realization. In that, the bank had filed an IA. Where is your IA? That is also not filed.
Yes, for
Has filed an IA.
additional issue. To frame additional issue. That was allowed and additional issue was framed.
He has filed an IA to frame an additional issue in respect of pleadings of written statement with regard to the maintainability of the suit under the provisions of the Surface Act. And in that regard, an issue was framed, and the court had dealt with that issue as a preliminary issue. It is a case of the defendant that
Page number 21.
That plaintiff is the highest bidder and purchased the suit property under the Surface Act, and also their authorized officer issued sales certificate on 18/6/2015. Thereafter, the bank authority issued an exemption letter of their personal appearance to the sub-registrar Gangavati. It is the case that the borrower failed to pay the mortgage money. On that count, the said property was sold in public auction as per law. Charge was created by depositing of title deeds to the bank on suit property. Once mortgage or charge is created until cancellation, the third parties have no right, interest and title on the property. It's a bondment duty of the sub-registrar not to register unless execution of reconveyance deed, and municipal authorities have no right to carry any changes in demand register. On that count, the sub-registrar and municipal authorities are proper and necessary parties to the suit. It is also stated that on receipt of the demand notice, they properly issued reply on 4/4/2016 through their counsel. And further, it is the case that all the proceedings arose out of the case or conducted under the Surface Act, and the suit of the plaintiff is barred by limitation. It is also the contention that the suit is not maintainable. Then the court had framed an additional issue, but that the defendant bank proves that the suit of the plaintiff is maintainable before the civil court under the Surface Act. The court, considering the respective arguments of the plaintiff and the defendant, and also considering the case law, court observes that the plaintiff could not question the very sale proceedings and other proceedings initiated under the Surface Act by the defendant authority. Moreover, before the auction sale in the year 2015, 4 years prior to that, the borrower sold the property in favor of one Ramakrishna. It is very clear that the sale deed is before the auction. The borrower already sold the property and the bank authority did not have the saleable interest, even though it was received under the registered mortgage. The court observes that even though the plaintiff got the sale certificate, he could not receive possession of the suit property. Now the sale proceedings are not completed and title involved in the suit property already sold by the borrower in favor of others. court comes to the conclusion that the sub-registrar and the municipal authorities are not proper and necessary parties. And it's the duty of the bank authority to issue sale certificate and hand over the physical portion of the property to the auction purchaser. For court also observes that if the plaintiff challenged any sale proceedings, definitely the present form of suit is hit by section 34 of the Surface Act and not maintainable. But the plaintiff got the possession and registration, but the plaintiff is seeking possession and registration of sale deed in accordance with law or for refund of his earnest money, and the same is maintainable before the court. Accordingly, the issue was answered in favor of the plaintiff. Next paragraph. Agreed thereby, the defendant bank is before this court. Learned counsel appearing for the petitioner submits that the suit is barred by limitation and he has not taken any steps to file the suit within the period of limitation. And after the sale, after 4 years from the date of sale, he has come up before the court. Further, it is submitted that the entire proceedings have taken place under the Surface Act, and there is a bar under section 34 of the Surface Act, and the civil court has no jurisdiction to entertain the suit. The court, without considering all these aspects, had answered the preliminary issue in favor of the plaintiff. He submits that the order and the revision is liable to be set aside. Next paragraph. Having heard the learned counsels for the petitioner, produced the entire material on record. The bank had sold the property in favor of the plaintiff. It is a contention of the plaintiff that by the time the sale had taken place, 4 years prior to that, the original borrower had sold the property. The bank, having taken the amount without even giving possession of the property and without even verifying the title to the property and without the property, now they cannot come up before the court that the suit is not maintainable as there is a bar under section 34 of the Surface Act. As rightly observed by the court, the petitioner, the plaintiff, is not questioning any of the proceedings that were had taken place under the Surface Act. And in continuation of the sale certificate that is issued, he is seeking a specific performance of the same. The contentions that are raised on behalf of the bank have no legs to stand, and the court had rightly held that the preliminary issue in favor of the plaintiff and held that the suit is maintainable. In the considered opinion of this court, the court had rightly considered these aspects, and the preliminary issue was rightly held in favor of the plaintiff, and this court finds no reasons to interfere. Accordingly dismissed. Yes, next.
So petitioner, wife's petition seeking transfer from senior civil judge Okeri to JMFC 3 Belgavi.
What is the distance?
The respondent is the husband.
Distance.
Sorry?
Distance, what is the distance?
Distance is 52 kilometers.
Any other proceedings are pending?
One is DV under section 12 of Domestic Violence Act.
Pending where the wife is staying.
Yes.
And this MC is of the year
MC has been
2023.
filed Okeri.
What is the stage of the MC?
Notice has been served.
You have not even appeared to.
No.
When did you receive the notice?
Now, again on 26/4/24, notice has been served. Issue notice to respondent by RPAD, call on 26/4/2024.
The present petition is filed seeking transfer of MC number 5 of 2023, which is pending on the file of the senior civil judge to carry to the Court of Family Court at Belgavi. The brief facts of the case are that The when is the marriage? The marriage was solemnized on 24/4/2016 at Halshankara Linga Temple, Dharwad. And out of the wedlock, they are blessed with a girl child. In view of the differences between the parties, the husband had filed MC number 5 of 2023 on 25/1/2023, seeking divorce. The wife had filed a petition under Section 12 of the Domestic Violence Act, and the summons were issued to the respondent. It was filed on 3/4/2024. It is submitted that it's difficult for the wife to travel on each date of hearing to Hokeri, where the case is pending, and she has to take care of the daughter. And he submitted that the distance between both the places is 52 kilometers. Next para. Notice is served on the respondent, and there is no representation on behalf of the respondent, and no wakalat is filed on behalf of the respondent. Next para. Having heard the counsel of the petitioner, present our material on record. Considering the fact that already a domestic violence case is pending at Belgavi, and considering the distance and the fact that the wife is taking care of the daughter and it's difficult for her to travel, this court deems it appropriate to allow the petition, and accordingly the following: the MC number so and so, number 5 of 2023, pending on the file of the Senior Civil Judge Kerry, is withdrawn, and the same is transferred to the Court of Family Court Belgavi. Accordingly, allow. Next. Yes.
Husband religion petition, my lord.
How much is granted to the wife?
10,000 is granted.
What is your income?
My lord, I am not working at a mobile shop. Who used to be.
You must have pleaded before the court. How much is your income?
Not 6,000 is my income, my lord.
That's what pleaded.
Please, my lord, not a single document she has produced, my lord. The trial court or.
And you say that your income is 6, court has granted 10,000.
Please, my lord.
Come to the order.
Lord, page 30 minutes, para 5.
Page?
Page 30, para 5. I file my objection, my lord. Even I produced 2 medical documents of my parents.
Where is your contention recorded by the court? Para number?
Para number 5 minutes, my objection, my lord, sir.
Let's read that. Let's read that.
But he further pleads that he does not have income narrated by the petitioner, and his monthly income is 6,000, which he earns from doing the repair of mobiles, that he has aged parents to be looked after.
Please come. Now, counsel, the petitioner submits that the petitioner has has filed his objections and stated that his income is 6,000. The court, having observed that there is no evidence produced on behalf of the wife in support of her contention that he is earning an amount of rupees
10,000 is granted.
Is earning 10,000 and is having other properties, but still the court had granted 10,000. It is submitted that it's very difficult for him to pay the said amount. Considering the same, there shall be stay of all further proceedings. No, there shall be stay of the order dated so and so, stay of all further proceeding pursuant to the order dated so and so, on the condition that he shall pay an amount of rupees 2,500 per month by 5th of every succeeding month, and the arrears at 2,500 from the date of petition till now shall be paid within 8 weeks from the date of receipt of the copy of the order. If either of the two are not complied with, the stay granted by this court stands vacated automatically. On such deposit, the respondent wife is at liberty to withdraw the money. List this matter on 10th of December. The registry is directed to issue notice to the respondent. Yes.
Number 16, Mediation. What she has responded?
It's a vice petition, seeking a transfer of matrimonial case from principal family court Dharwad to senior civil judge Zurun Gadag.
Gadag?
Yes, ma'am.
What is the distance?
Pardon me?
Distance.
Distance is more than 100 kilometers, my lord. And
When is the MC filed?
MC filed before
2024.
Yes, my lord. And petitioner is having a small kid, my lord.
Aged about?
It's about 2.5 years, my lord.
Please come. The present petition is filed seeking transfer of MC number 221 of 2024, filed with the wife, filed with the husband under Section 9 of the Hindu Marriage Act, which is pending on the file of the Principal Judge Family Court Dharwad to the Senior Civil Judge Ron, Gadag District.
Yes.
Gadag District. The facts of the case are that the marriage had taken place on 12/2/2016, and out of the wedlock, they're blessed with the boy who is 2.5 years old now. In view of the differences between the parties, the wife is staying at her parents' place. At her parents' place.
Yes, yes, ma'am. Please, ma'am.
At her parents' place. It is submitted that she is not in the position to attend the court at Dharwad, and the distance between both the places is 100 kilometers.
More than 100 kilometers.
More than 100 kilometers. Even for traveling, apart from the inconvenience on other grounds, even on financial grounds also, it's very difficult for her to travel, considering or travel. The notice to respondent is served. I know Wakalat is filed. Considering the submission of the advance for the petition, and considering the fact that the distance between so and so and so and so, Dharwad and Ryan, is more than 100 kilometers. She's having a small baby to take care, and considering the financial constraints and the inconvenience, this court deems it appropriate to allow the petition, and accordingly the following: so and so is withdrawn from so and so and transferred to so and so. Yes, next.
Number 63, there is particularly Shana respondent number.
Vice President. I filed Wakalat for respondent.
You filed Wakalat? When did you file?
Today, ma'am.
From Belgaum to Vide.
Belgaum to?
Vide.
What's the distance?
It's about 150 to 160 kilometers. And
154 kilometers. Lots, maybe allowed.
The MC is filed seeking transfer of OS number 6 of 2024, filed by the husband on the file of the family court Belgavi and transfer the same to the senior civil judge court Bilagi. The facts of the case are, and the marriage has taken place on 23/1/2022. And it is a case that they only led their marital life for a period of 2 to 3 months. As she was, and she has been harassed by the respondents in the family. It is stated that the respondent husband had filed OS number 6 of 2024. Why is suit? Suit on the file of the family court Belgavi for restitution of conjugal rights. She's residing at so and so. So residing at so and so vide, and the distance between both the places is 134 kilometers, and it is very difficult for her to travel all the way to so and so on each date of hearing. Next, learned counsel appearing for the respondent submits that the wife has not given any proper reasons for the transfer, and no grounds are made out for transfer of the case from Bilagi to Belgavi. From Belgavi to Bilagi. It's where having got the conscience on either side, produce material on record. Considering the fact that the distance is above 134 kilometers, and it's difficult for her to travel on each date of hearing, and considering the convenience of the wife, this court deems it appropriate to allow the petition, and accordingly following so and so is withdrawn, so and so accordingly allowed. Yes, next.
Number 64,
Widespread citizen transfer from Chitradurga to Yelburga, which is almost 200 kilometers.
When is the MC filed?
The present respondent has filed the diverse petition before the principal senior civil judge.
Which year is the MC?
It's 64 of 24, page number 11.
Yes, please come. The present petition is filed seeking transfer of MC number 64 of 2024, pending on the file of the first additional senior civil judge at JMSC of Chitradurga to Yelburga. The facts of the case are that the marriage had taken place on 1/5/2019, and it is a case of the wife that she has been harassed by the family, and she has been kicked out of the house. Thereafter, the husband had filed a petition seeking divorce, that is MC number 64 of 2024, on the file of the additional civil judge at JMSC Chitradurga on 22/4/2024. It is stated that the wife had filed criminal misdemeanors number 1014 of 2024 on the file of the civil judge at JMSC Yelburga seeking maintenance, and that notice is issued to the husband, and the same is pending consideration before the court. It is submitted that the distance between both the places is 200 kilometers, and it's difficult for the wife to travel on each date of hearing to the before the court at Chitradurga. No notice is served on the respondents, no wakalat is filed. It's for having heard the counsel for the petition for as a material on record. Considering the fact that the distance between Chitradurga and Yelburga is 200 kilometers, and considering the convenience of the wife, this court has deemed it appropriate to allow the petition, and accordingly follow so and so. Yes, next.
Number 65,
What's why is petition seeking transfer from Principal Judge Family Court Hubli to Principal Judge Family Court Bagalkot?
Bagalkot.
Please, ma'am.
And
the
the
distance
MC
is 170 kilometers.
When counsel for the petitioner submits that the husband had filed MC number 345/2024 on the file of the family court opening, and the petitioner is a resident of Bagalkot, and the distance between both the places is 170 kilometers. As such, they have come up with the present petition seeking transfer. Considering the submission, they shall be stay of all further proceedings on the file of so and so, in MC number so and so, till the next date of hearing. Petition is permitted to take out a hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to the defendant by 25th of November. List this matter on 28th. Yes, next.
Number 66, Finalized Village.
The petitioner here is the respondent in the HRC petition, Your Lordship. And Your Lordship, I have filed the amendment application which came to be rejected, Your Lordship. I wanted to bring certain facts, Your Lordship, subsequent development, Your Lordship.
Please come to the order.
Please, Your Lordship.
Impugned order.
Please. It is at the next, Your Lordship, page number 11. It starts from page number 11. May I read the relevant portion, Your Lordship, which is on page number 15. Page number 15, Your Lordship.
Page number?
15, 1-5.
No, let's read from the beginning. Order.
The respondent has filed I number 5 under order 6 rule 17 read with 151 of CPC.
HRC is of the year 17.
Please, Your Lordship.
Yes, read.
Praying to permit them to amend the objection in the interest of justice. In the affidavit, the respondent stated that the petitioner has entered into an agreement of sale with him on 30th 10/2013 with respect to the scheduled property by receiving an advance of rupees 1 lakh and the consideration amount was rupees 1,50,000. On 1/4/2015, the petitioner has executed another sale agreement in favor of the respondent and his sister by receiving consideration amount of rupees 5 lakhs. Thus, the petitioner has received a total advance of rupees 6 lakhs. In spite of repeated request and demand, the petitioner has dragging to execute the sale deed. Therefore, there is no relationship of landlord and tenant between the petitioner and the respondent. He and his sister have filed suit for specific performance of contract against the petitioner in OS number 237/2021 before the Honorable First Additional Senior Civil Judge and JMFC Belgaum. Hence, the said aspect is to be
This plea you have not taken before the while you are filing your objections.
No, Your Lordship. That time this OS was not filed, Your Lordship.
Not OS. Filing of OS is not the factor. When did you file your objections?
In 2018, Your Lordship.
2018. All these transactions which you are referring to are of the year 13, 15, except the suit. That doesn't matter. It's not about the suit. All these facts were never pleaded.
They were pleaded, Your Lordship. May I take Your Lordship's attention to the objection that I have filed?
Proposed amendment. What is the proposed amendment? Let's see.
Please.
There is no dual relationship of landlord and tenant. Can you take it by way of an amendment after 6 years?
Your Lordship, subsequently, Your Lordship, I have filed the suit for specific performance.
By filing a suit for specific performance, this dual relationship of landlord and tenant.
Initially, I came in possession of that property as a tenant, Your Lordship. But subsequently, they entered into an agreement of sale with me by receiving the consideration amount, Your Lordship, and kept on promising that I will execute the sale deed in favor of you, Your Lordship. That I have already pleaded in my objections, Your Lordship. Only thing is, Your Lordship, subsequently, since they have refused to execute a sale deed in my favor, I filed a suit for specific performance.
You have filed a suit for specific performance.
Please.
Now, why should this? What is the big difference that's going to make in your pleadings by this? What is the necessity for amendment now?
Your Lordship, subsequent facts are to be pleaded before this court, Your Lordship, and therefore I want to insert these facts in my objections, Your Lordship.
No, the court will not decide all those aspects. No, how can anybody file a suit for specific performance in 2021 for something that has happened on 1/4/2015? And how is it relevant to consider your case? Whatever is the result of the specific performance suit, as far as this eviction matter is concerned, court is bound by what did the petitioner, what is the petitioner's case? What is your objection to that?
But Your Lordship, how the relationships have changed, Your Lordship, because he has.
That you have pleaded so. That you have pleaded, according to you, you have already pleaded in your objections.
I have already stated only with respect to the transactions, Your Lordship. Subsequent filing of the suit was not.
Whether you file a suit or not, your agreement and that there is no relationship of landlord and tenant which you have already taken, it will not change. Why should we unnecessarily come up with these kind of applications and drag on the matter like this?
No, Your Lordship, because subsequent facts need to be brought before the court, Your Lordship. Therefore, Your Lordship, I have filed this application.
And why this much of amendment? If only subsequent facts are to prove, suit number is number so and so is filed. That is what is relevant.
Your Lordship, in my second paragraph, Your Lordship.
No, but this is all is amendment. Everything is amendment. All this why? No, you not necessary.
These facts, Your Lordship, with respect to the transactions, Your Lordship, I have already stated in
only in the last 3 lines you said about OS number so and so, which is subsequent to your pleading. And even the suit is filed in the year 2021. When is this IA filed?
In 2021 itself, Your Lordship.
I can understand you have filed only that particular, with regard to the suit. All are not part of it. Why should the court consider all these pleadings? Why should it permit you to, fill up all your latches?
There is no subsequent this thing, the transactions which have
already
taken place.
Why you want an amendment when all these facts are much prior to the suit, much prior to your objections?
Your Lordship, may I take Your Lordships to my objections, Your Lordship?
No. Please look at your proposed amendment. In your proposed amendment, you started everything right from afresh. That's not necessary. If really what is you want to bring on to the notice of the court that the suit is filed, you would have said it so. For seeking specific performance, I filed the suit. And how is it going to alter? How is it going to affect? What is
the conduct of the respondent, Your Lordship? He has been prior to this, Your Lordship.
And your conduct also. Suit is the
Lordship, I have filed one more suit, Your Lordship, way back in the year 2016, which is suit for injunction, Your Lordship. The trial court got confused with these two aspects, Your Lordship, and they have reasons saying that these facts were already brought to the notice of the court. Whereas, Your Lordship, that suit is totally different.
Even otherwise, you cannot be permitted to say all these things, except only one line that you filed a suit for specific performance. Because all these aspects are much prior to filing of your objections, which need not be, you cannot be permitted to take all these pleas in the year 2021 by way of this petition. There's nothing but delaying tactics.
Your Lordship, in my paragraph 7, in my objections, Your Lordship, I have stated that these transactions have already taken place. But I have not mentioned in details as to on which date.
Then your fault.
That is what I have been elaborating here in my.
Not necessary. That permission court will not grant you. You should say,
the dates,
in spite of due diligence, these facts could not be brought to the notice of the court. What is a due diligence? It is not something which is not in your knowledge. Everything is in your knowledge. So, Order 6 Rule 17 is not to fill up your latches.
Anyways, it will not alter my stand, Your Lordship. These transactions.
That doesn't matter. Then whatever is there is there.
Your Lordship, I am admitting these transactions. Only thing is dates were not mentioned.
In a petition of 1721, how can you be permitted to say all these things?
Your Lordship, only dates is what I am just elaborating the facts, Your Lordship. Because in my
Why you couldn't do it? Why you couldn't do it at the earliest point of time? No, the plaintiff will also forget so many things to say. Now again we'll permit him to do. Again you will file another petition. That's not the way it goes on. Please come.
Your Lordship, at least I be permitted to substitute the subsequent facts, Your Lordship. That OS came to be filed subsequently, Your Lordship, and I be permitted to at least add the para B, Your Lordship. 7B. Wherein I have stated that it's humbly submitted that the petitioner went on dragging the execution of the registered safety.
Did you say so? Did you say so in your objections? Please come to your objections. Let's see your objection. First of all, filing the suit in 2021 itself shows the bona fides of your client. Filing a suit for specific performance in 2021.
Because Your Lordship,
After,
he kept
after
on promising
HR,
saying that
after
he
these
will
petitions.
execute the same.
Huh?
He kept on promising, Your Lordship, saying that he will
Even after
execute the
filing
same.
HRs in 2017, will he promise you that he will execute the same day? And will you believe him? Let's see your objection.
Please.
Yes. Now, where are your specific governments? Para number 3, please start reading.
Please. In fact, the real facts of the case is that the respondent Mrs. Surakshana and another her sister Srimati Smita have both filed long back in the year 2016 on 24/6/2016 before the Honorable Principal Civil Judge Junior Division Belgaum a suit for declaration and permanent injunction against the said petitioner, which is even today pending before the Honorable Principal Civil Judge Junior Division Belgaum, wherein have mentioned that the respondent and petitioner are the Goldsmith family and knew each other since many years. Though respondent's father, Nagesh Vishnu Revankar, then was a goldsmith in Belgaum. The respondent was working in a military school till the date of her marriage, got married in the year 2007. As such, she was to vacate her government quarters and got the petitioner's house, its terrace, etc., out of RS number so-and-so, Madhwa Road, adjacent to Dr. SPM Road, cross number 2, Belgaum, which was or is belonging to the petitioner's ownership. The said house was necessary for the immediate shelter of the respondent's elderly and ailing advanced age father to stay along with him to then spinsters, daughters and one son who were all studying in different colleges in Belgaum. Respondent occupied said house initially on month-by-month rent from 2008. Besides, the petitioner offered said house for sale to respondent, putting them into actual and peaceful possession and enjoyment in 2013 for total consideration of 15 lakhs. Out of that, respondent and her sister together have paid in all 6 lakhs as per their amicable understanding by way of cash, which was accepted by the petitioner, and respondent also gave in cash under mutual understanding as per the demand of petitioner. Even otherwise, the very petitioner has given in writing on the bonds purchased by him respectively dated 31st October 2013 for 1 lakh from respondent's sister Srimati Smita, who is not made party as required.
In the year 2018 itself, you say in a HRC petition asking the court to direct the petitioner to execute a sale deed in your favor.
To 2021 I have held.
35, page number 35, para number 7, you say direct him to execute sale deed as required under law and respond ready and willing to pay balance consideration of 9 lakhs. This is what you said. So on 28 to 2018, and you file a suit in the year 2021. How is that relevant for this deciding this issue? Yes. Call the passwords.
Serial number 95. They would be respondents.
Serial number 1, password matter.
One, amended cost. Land counsel for the petitioner has filed the amended cost item is permitted to carry out the corrections. List this matter after the list this matter on 12th November. Yes.
Serial number 5, password matter. Contentious serial.
Serial number 5. Yes. Ready? Yes. Use the mic.
Petitioner notes White's petition, whereas White she has filed an interest petition before the Family Court Belagavi in a criminal misdemeanor number 415/2016 notes. For the petition filed by the White is came to be dismissed notes. Notice impugned order is at page number 24 notes.
Yes.
Where in the notes, the petition filed under section 125 CRPC is dismissed in the notes by Fayaz Hazard, which is hereby dismissed notes. Notice the reasonings has been assigned at page number 20 minutes.
Then why are you not paying the process?
Because he is staying in Dubai, my lords, and we are not getting a sufficient address, my lords, to give the notice, my lords. Even, my lords, both of them are staying separately last from 12 years, my lords. Sir, marriage has been taken place in the year 2011, and only for the period of some days they stayed together. And subsequently, my lords, after the marriage only, my lords.
You know, how will you serve the notice?
That is.
What is furnished before the court?
Whatever the address which have been stated before the trial court, notice, that only have been furnished here, my lords, but on that address, my lords, it is insufficient, my lords.
Before the trial court, what has happened?
Yes, sir.
Before the trial court notice is served?
No, notice is not served because, my lords, even the trial court advocate, even he is not taking the notice. He is saying that, my lords, there is no proper instruction from. I will furnish, I will take out the correct address and I will take out the stuff.
Please understand. Before the trial court, has he appeared?
There he has been appeared.
On the same address?
Yes, my lords, on the same address he has been appeared. But here, my lords, it is.
Now, what it says as per the postal shara?
It is insufficient address, my lords.
Please come. Then counsel for the petitioner submits that as per the address before the trial court. The very same on the very same address is taken out notice on the respondent. He submitted that before the trial court, he has appeared before the court, basing on the notices served on the same address. He submits that this is a mischief to avoid the service of notice. The petitioner is permitted to take out notice and is directed to pay the process within a period of 1 week, and shall take out, and the notice shall be sent to the very same address.
Please.
Yes, list after service. Yes.
Serial number 28, password matter.
28.
28.
Password nursing good one. Password nurse company application filed nurse.
Assorless parties.
Yes.
Also,
End of the list. Call it 4:30. Yes, next.
Number 20.
So there are two petitions has been filed. One they have filed and one I have filed been filed, my lords. And in one petition, my lords, the court has granted 6,000 amount of maintenance, my lords, to children. Kindly go through the impugned case. Impugned
6
order, my
months,
lords,
6,000, that is,
to the children, my lords.
that is 3,000 each.
3,000 each.
5?
And wife it has been dismissed, my lords.
Again, is that you are before the court.
Yes, my lords. Wife now she is before this statement.
And you are also seeking enhancement for the children.
No, no, no. I'm not seeking any enhancement for children, my lords. I'm seeking.
What is your case?
It's a sufficient of the respondent number 2 to 3. The 6,000 is sufficient, madam. 6,000 is sufficient. The petition is.
No, you have filed RPFC.
Yes, madam.
Questioning that you filed RPFC.
Yes.
So you say that no, as far as the children 6,000 is concerned, no, you're not arguing on that. Let's see the impugned order. Impugned order.
But the impugned order is at page number 33 minutes.
Where is the reasoning? Come to the reasoning part.
The reasoning, my lords, at page number 24, my lords.
Read from page 20.
20 minutes. Yes, sir. The learned counsel.
Turn this to a side. No?
Yes. Paragraph number 14 minutes.
What is the age of the children?
But the age of the children is met in lords at 7. Petitioner number 2 is 7 lords and petitioner number 3 is 6 years. Minutes.
My restitution petition is not allowed, madam. Section 9. It's not a joint matrimonial life.
So, without a reasonable cause, you are staying away from the husband. You are not entitled for maintenance. Court has rightly held.
But my lord, I have, my lord, even if the restitution petition is allowed, my lord, even if I had been there, he has to take it properly, my lord.
Go.
And the husband, my lord, now I don't have any sufficient means.
Then go to husband. Why should he pay you maintenance?
But I don't have any sufficient means also, my lord. Now
That's what. Why are you staying away from the husband?
Lord, even if I had been when, he has to take care of it properly, my lord. And when matter has been
You will
referred.
take care. Go. Please come. Agreed with the orders passed in. Criminal miscellaneous number 257 of 2018, dated 11th August 2023. Both the husband and wife are before this court. The wife's petition is RPFC number 1000119 of 2024, and the husband's petition is RPFC 1000009 of 2024. The wife had filed criminal misdemeanors seeking maintenance for herself and for her 2 children. It is a case of the wife that the marriage had taken place on 25/11/2009. Out of the wedlock, they are blessed with 2 children. On 23/2007, at the instigation of the parents, the husband let the petitioner out of the matrimonial home. Since then, she has been residing in a parental home. She is not able to bear the school fees and other expenses of the children. the parents of the wife or the elderly persons, and they have asked the husband to take her back, but he has refused for the same. According to her, the husband is financially sound and is leading a luxurious life. And he is having income of an amount of rupees 50,000 per month. It's the duty of the husband to maintain the wife and the children. The husband filed his statement of objections. In that he has stated that in the married life of 9 years, the wife has stayed with the husband for hardly 4 years. And at the instigation of her parents, she used to go to her parental home without informing the same to the husband and his parents. Petition, the husband had waited for her to mend her ways. And in the month of April 2017, the wife had left the company of the husband, went to her parental home, ignoring the education of the children. And since then, the wife is staying in her parental home, and all the efforts made by the husband to bring her back went in vain. Thereafter, he has filed MC number 251 of 2018 seeking restitution of conjugal rights. The court had considered the respective stance of both the parties and dismissed the application as far as the wife is concerned. While dismissing the application of the wife, the court has observed that in MC number 251 of 2018, the court gave a categorical finding that the wife had left the matrimonial home on her own and she has withdrawn from the society without reasonable excuse. And when Section 125(4) of CRPC also disentitles a wife from receiving maintenance from her husband when she refuses to live with him without sufficient reason. The court observes that the evidence in both the matters, that is, in the MCA as well as in the criminal miscellaneous, is recorded almost simultaneously, and as both matters are disposed of simultaneously, though passing separate order, the evidence adduced by the husband with regard to neglect or refusal on the part of the evidence adduced by the wife with regard to refusal on the part of the husband is not sufficient. The evidence of PWT also do not help to the case with the wife in this regard. Hence, the court comes to the conclusion that there are no reasons to grant maintenance to the wife. When it comes to the maintenance of the two children, the court has observed that there is no evidence to show that the husband is earning an amount of rupees 50,000. Considering the age of the children and their requirement, the court had directed the father to pay an amount of rupees 3,000 each to both the children. The order of the court, as far as dismissing the application of the wife is before this court, and the father is before this court questioning the maintenance that is granted to the children. Learned counsel appearing for the mother the wife submits that the husband has an obligation to maintain the wife. When he has failed to take care of the wife is not having sufficient means to maintain herself, the court ought to have granted maintenance to the wife. Then the reasons that are given while dismissing the application are contrary to the settled law. The court failed to consider the fate of the women. The court has considered and focused more on the order passed in MC for restitution of conjugal rights without independently appreciating the matter before the court. It is submitted that the wife is entitled for maintenance. Next one. Learned counsel appearing for the respondent further submits that the MC filed by him for restitution of conjugal rights was decreed and the wife had failed to join the husband. In the light of section 125(4) of the CRPC, the wife who, without a reasonable cause, who is staying away from the matrimonial home, is not entitled for any maintenance. The court had rightly dismissed the petition. He submits that though there is no material on record to show what is the income of the husband, granting maintenance of an amount of rupees 6,000 to both the children is on the higher side, and the same is liable to be reduced. Next one. Having heard the counsels on either side, there is the material on record. The husband had filed MC for restitution of conjugal rights, which came to be allowed. And as observed by the court, both the petition under 125 CRPC and the petition for restitution of conjugal rights simultaneously were heard, evidence was adduced, however, 2 independent orders were passed. So the evidence before the court shows that without a reasonable cause, the wife is staying away from the matrimonial home. On that count, the court had rightly held that the wife is not entitled for maintenance. It is an admitted fact that even after the order is passed, the wife had not joined the husband. Then coming to the amount that is granted towards granted to both the children towards maintenance. If it is a case of the husband that he has no means, then as he has appeared before the court, he should have adduced the evidence that he is not having sufficient income. When he was taking care of the 2 children while they were with him, and he was taking care of the school expenses and other things, he was stating that granting of an amount of rupees 6,000 is on the higher side, is without any basis. This court is not able to appreciate this and contention of the counsel for the respondents. In that view of the matter, this court do not find any merits both in the appeal filed by the husband, both in the petition filed by the husband as well as the petition filed by the wife. Accordingly, both the petitions are dismissed. Yes. 30?
36.
Where is he? You have not seen him today? Heard the learned counsel for the petitioner, no representation for the respondent in the forenoon as well as in the afternoon. This matter as part for tomorrow. Tomorrow we'll pass out whether he comes or not. Yes.
I am for respondent.
Yes.
Petition to learn challenging the order of maintenance. The trial court has granted 13,000 rupees maintenance to us.
To the wife?
Yes.
What is your income? Your income?
But so far as income is concerned,
He has not
affidavits are not filed.
one small solution. The petitioner is a government servant working as a education department as a account officer, and he has not produced a single document before the trial court also. And directly petitioner to produce the salary certificate. He is getting more than 1 lakh rupees, madam.
So far as the trial court will not since the
We'll also then ask them to file a petition for enhancement.
we'll both of us will file our statement of assets and liabilities, my lord.
Is it your case that she is working?
No. No.
Is it your case that she is working?
We have contended that she is working as a teacher in a primary school.
No, madam.
Both the petitioner and the respondent shall file the respective statement of assets and liabilities as per the law laid down with the Honorable Apex Court in Rashish versus
No,
Neha.
one small, the direct to produce the salary certificate.
Along, he has to, and specifically the husband shall place before the court the salary certificate. List is matter on 26th of November.
Please.
Yes, next. Yes.
Please, ma'am. In this case, last time I produced.
Yes.
I produced, I took out steps to respond number 7 by paper publication. Last time I have produced along with the memo, the paper publication. Respond number 7, my lord.
As for the order passed by this court, which is the date of order? The notice to respondent number 1, the petitioner has taken out the notice from the council by, on the first respondent by way of paper publication.
Respond number 7, my lord.
Respond number 7.
7.
When is the order? By order dated 23/1/2024, this court has permitted the petitioner to take out notice by way of by way of substituted service by order dated 23/1/2024, when counsel has filed a memo to that effect, and as with order passed by this court, he has taken out notice. The notice, hence notice to respondent number 7 is held sufficient. Then all the notices are completed.
No, yes, ma'am. Yes, ma'am.
Then why don't you argue? How many steps for argument for that and this? List is matter on 13th. No further adjournments. Yes, next. Yes.
Small correction in my fact. My statement as to the recognition by the tourism department is concerned. There was only at one particular moment the Ministry of Tourism had prepared a dossier that it is some of these hotels be classified as a star hotel, but nevertheless, even subsequently they made a letter of it has never taken the status of a star hotel, and till all these years, even subsequent to this, the licenses are issued are only in pharmacies. If my lords are pleased, I can produce the copies also. That's what I was not a mistake I have committed in narrating the fact that the 6A license was even subsequently, my lord.
You have filed your objections?
This first case we have filed. That is, my lord, in the objections all these notes are not. I can read the objections. There's no documents are produced. All this I have taken the instruction to the effect that all these years, subsequently and prior, the licenses are in policy of only. If at all it is in CS6.
No, at least before doing all that, are you not supposed to issue any notice?
Yes.
No. When did you issue?
No.
You straight away passed an order directing him to pay. Now, whatever it is, either your mistake, his mistake,
Demand
something.
notice has been issued. Demand notice has been
You
issued.
can issue a demand notice straight away. You issued a note license to him under a particular category. According to you, he shouldn't be considered under that category. The license should have been under some 6A category. If that is the case, you should have issued a notice to him saying that yours is a star hotel and why have you obtained a notice? By misrepresenting to the authorities, you obtained a notice. So, you give your explanation to that. Then he will submit his explanation. If if there is any suppression or if he has done anything, then it could have been no because of the what is that
Audit
CAG?
objection.
Because of the audit objections, he is not, you have rules. You are bound by the provisions, not by what CAG says.
Audit is done of their books, not my books.
At the time of making an application for granting of CL7 or CL6A or CL14, they have suppressed the material fact.
Where did you ask them about it? Because you cannot take unilateral decision. First of all, you don't even know when that hotel is now has a status of a star hotel. Just because the CAG says you have your own independent, there should be independent application of mind by your officer. Is it not? No, had he done it, all this litigation would have not been there till now. No, there is a lot of ambiguity everywhere. Now we have to accept what he says.
While I rightly pointed out that at the time of issuance of a license, we have to verify it and we have to declare it. You are supposed to apply the application under CL6A. While I rightly pointed out that. For that I will get instruction for her. But the endorsement issued by the Deputy Commissioner, it was remanded back to the, they have approached the higher authority commissioner also. And
here the inquiry is, no, not about this, the CAG report. That's not that would not be the, he must have said that, why have you done? Because he said you just like that, simply you cannot consider them as so. But you should ask them, what is it happening? When is it? If not so, why you have not done? Then after that, your notice, your whatever the demand notice you have issued, that should have been done by that. You should
in
have
earlier occasion itself, it has to be done.
Done, but you have not done.
No. For that, I will get instruction. But the endorsement issued by the Deputy Commissioner, the order, which clearly reflects that they are suppressed the material fact at the time of filing an application.
You have assumed it that they have suppressed it. So then the observation should contain on so and so date we have given you have applied for the renewal of license. On so and so date you have been given the status of a recognized as a star hotel. So from that day it should have been so. From that day to this day, this is the business you have conducted. That should have been that.
For that I will get instructions regarding this. I will get instructions.
You cannot.
In the next case, exactly the same thing has been made.
No.
The deputy commissioner accepted my stand and directed the refund of the amount collected. For that, the excise commissioner tells his subordinate deputy commissioner of excise to file an appeal before him, and the excise commissioner allows the appeal and satisfies the order of the deputy commissioner. My Lord, you kindly see this.
As per 61 subclause 2, they have to file an appeal before the Deputy Commissioner Revenue. Directly they have approached the Excise Commissioner. That is wrong. That's why it is remanded back. Thereafter the endorsement has been issued in that matter. That is different fact and letter.
What are the facts in that case?
Same fact. There was also remanded from the High Court, the matter was remanded. Then the Deputy Commissioner of the district heard me, passes a detailed order and directs the refund of the amount collected. Against which,
no, the same licenses.
Another license.
That is different. That is partnership firm. Without informing the authority, they have entered into taken one more person to the partnership firm. Before that, they have to inform me. As per 17B of the Excise Act, they have to inform. They have to give an representation. We are changing the constitution of the firm.
All these
which was not changed.
Numbers.
They have not at all made any representation.
Please to see for a moment. In the next case, this is 100476. The Deputy Commissioner of the district accepted my contentions allowed by contentions, and directed the refund of the amount already collected.
That was rejected by the commission, excise commission. That was,
Permit me to
that was
submit.
rejected.
Permit me to submit. I will submit how your act, government act.
Here you also, let him
On that, my lord, kindly see page number 42. The excise commissioner, what he does is, directs his subordinate deputy commissioner of excise to file an appeal before him. And in that page number 42, may kindly see, the deputy commissioner of excise describes himself as state of Karnataka. He is a much subordinate to the state of Karnataka. An inferior officer calls himself state of Karnataka, Department of Excise, by deputy commissioner of excise, before excise commissioner. The excise commissioner announced the order of the deputy commissioner, who has rightly.
How will he file appeal against his own order?
Who? That's what I mean. The next case it is done. Deputy Commissioner of Excise questions the Deputy Commissioner's order before Excise Commissioner, describing himself as a state government. So everything is state government. If the other side, because I thought it matter can be concluded today, then it might not be kindly fixed. I produce a copy of the license also, and the procedure says that before renewal inspection takes place by the Inspector of Excise, there is a hierarchy. Inspector of Excise, Deputy Superintendent, and Deputy Commissioner, they carry out.
So, Government Reader, this has to go. Yes. The first petition has to go. Please, will afford you an opportunity. Get instructions from your.
Have it on 23rd or 25th. I will bring all the documents. I will get all the instructions. Moreover, they have suppressed.
Not 23rd.
Before
We'll have it
November.
on.
Yes.
Except 8th one Kalburgi.
We'll have it on 20th.
20th.
This is matter on
22nd on
20th.
Friday. 22nd on Friday.
Friday it is not possible.
Friday.
Let's have it on 20th.
Please.
List is matter on 20th. By the time the government reader shall place before the court all the particular file pertaining to this case.
Moreover, they have to file what they have applied for license. They have to put forth all the documents before this. They have not at all filed.
Application
records are with you.
They have. No.
Your record will disclose everything. Let's see.
They have any endorsements, which they have taken acknowledgements. When they have applied for the authority to give a license, they have a document. They have to prove. They have not at all said anything.
What?
I have applied for so and so. I have applied for 60 or 78. They have not at all said anything. Directly they have
What document he has placed before you?
Please.
Either he submits or you submits, it will be there with you. Please place the file. We will
And I also.
List this matter as part heard.
Enlighten my lord as to the procedure of the assembly. There's a committee of public accounts. Otherwise, audit objection will, no, there cannot be any officer in service if the audit observation is said. Even the controller of audits can say that one paper is given to the lawyer. It's a court paper. Why did you give?
This all these matters, 67,
Yeah, all the
67, 72,
67, 69.
60,
in
67, 60, not 69, 70 or 69?
72, my lord. 67, 72, and 80. In 80, they have not served the copy on us.
67, 72, and 80.
80.
All the three matters tagged together.
In 80, they have not served the petition copy.
In which matter 80?
80.
Please send him
principal bench it was filed and transferred.
give him that copy. A copy of the petition shall be served on the government figure. 80. What is the other one? That also tag along with this, we'll see. It's an independent one.
I'll only take your lordship 2 minutes, if my lord sir.
There was a stay for them. There was a stay for them. I have to file my statement of objection in 69.
May not, the next state officer may take instruction, it may not survive because for other pending contract default, the defaulter died. Benami, he was a Benami, he died. For that, recovery is done self-acquired property by arrears of land. The state has not
Recovery proceedings are initiated, land recovery.
Yes, land
revenue.
Yes, but on that day, auction has not taken place. Whether it will survive now or what the stand government.
The court has stated that in the interim order, the proceedings has to be go. Then the final subject of the writ petition, the stay was granted for them, subject to the outcome of the writ petition. Hence,
No,
the auction proceedings have been taken place
even
on
on
that
this
day.
also, whatever you want to, your objections in this petition, this shall also be fined by that day.
It will take some time. This is 69.
So this matter, list this matter on December 2nd. By the time the land council, the land government leader shall file the objections.
Please.
Same day or other day?
No, others.
He wants it because they have to file the objections. Yes, next. Intermodal early grant is extended to the next date of hearing. Yes, next.
Number 16. 16. Usman Farati, Sabir Ahmad.
Responding to your lordship, the main petition has been dismissed, your lordship, by the wife instituted before the honorable trial court has
Land
been
council vote for the petitioner on the last occasion has submitted that the petition filed with the wife has been dismissed and he sought time to place on record a copy of the order. Today there is no representation on behalf of the petitioner, and the land council for the respondent has also stated that the petition is already been dismissed, hence this petition has become infructuous. Dismissed as infructuous. Yes, next. Counsel for the respondent is present, no representation.
Girishas Pulmani.
last occasion also they have taken time.
You find him online? No, he's not there. No representation for dismissal tomorrow. Counsel for the respondent is present. Yes.
Number 72.
72 is in the same batch.
Number 73. Ashika Gulsi.
Yes.
Petitioner who is the respondent before the court below.
Counsel for the respondent is not there. Counsel for the petitioner.
Lord, senior will come. You can start now.
But the petitioner hearing was the respondent before the court below. He has called in question the order dated 22/9/2022 passed by the Principal Judge Family Court, Belgaum. But Annexure A is the impugned order, my lord. My lord, you find it in page 16. Wherein, my lord, the respondent's hearing.
What is the objection on the maintainability? What petition is filed?
On an earlier round of litigation, the suit OS number 12 of 2003 for maintenance was filed by the mother of the respondent hearing, along with the respondent, and the suit came to be dismissed. Against which MFA was filed before this honorable court. And there are other litigations also, wherein the present petitioner filed a decree for divorce of the mother, which was allowed, and against which appeal was also filed, that was also withdrawn. And suit was also filed by the present respondents against the petitioner for partition and separate portion. That was also withdrawn. So when the suit for OS number 12 by 2013 for permanent alimony was filed by the mother along with these respondents, that was dismissed, against which an MFA was filed before this honorable court. In the MFA, a compromise petition was entered between the petitioner and the mother and the respondents, wherein I have produced the copy of the compromise petition also, my lord. My lord will find it in page 34 Annex C.
Yes.
The relevant page, my lord, is in page 36. Para 2.
Yes.
May I read, my lord? 36, my lord. This order passed by this honorable court, compromise petition where in the decree, my lord, the compromise petition is extracted. May I read? The parties herein after the due deliberation and also
I've
after.
seen that. Thereafter what happened?
No, my lord, after this, my lord, the petitioner has paid rupees 6 lakhs towards permanent alimony in respect of the mother, and in respect of the present respondents, rupees 3 lakh is paid, and the suit filed by the present respondents was withdrawn, and the appeal filed by the mother was. So all the cases against the petitioners were withdrawn by virtue of this compromise petition. One of the conditions in the compromise petition is that, my lord, at the bottom 2 lines in the bottom, my
I've
lord,
seen that. They will not
yes,
claim any.
the full and final settlement, the appellants herein have agreed not to claim any maintenance in future from the.
Fantastic.
Yes. And in the next paragraph, Lord, the amount which is has to be paid is also extracted. Now, my lord, after lapse of this order, my lord, is passed in the year 2007, my lord. And after lapse 2017, my lord. Now, my lord, the present respondents have filed a petition under section 125 seeking maintenance of rupees 15,000 per month each from the present petition. The present petitioner is father and the respondents are daughters. Now they have attained majority. At the time of compromise, they were minors. They did not challenge that compromise petition after attaining the majority. Now, after attaining majority, they have filed this petition saying that they are in need of money of rupees 15,000. But the very maintainability was objected by the present petitioner, and the court below rejected the objection, framed an issue, points for consideration, and rejected, and holding that the petition is maintainable. It has to be decided after full-fledged trial whether that compromise is binding on the respondents. So, Annexure A, my lord, is the impugned order. My lord. May I request, my lord, the relevant parameter.
What do you say?
Lord, insofar as the compromise before the High Court, my lord, he can't dispute that. I'm not disputing that, my lord. Our limited request why we filed this petition, my lord, we filed the second petition in 2017, my lord. For nearly 5 years, he is a police officer, my lord, in Mumbai, my lord. For 5 years, my lord, he did not appear. 2022, my lord, we were able to serve notice and get his appearance.
No,
now,
it's not about that.
Please,
no,
Lord, I am only saying this for the conduct.
Let's forget about his conduct. As per the settlement, as per the compromise, had he paid the money to you or not?
Please, Lord, we have received the money. We are not
Then what is the purpose of filing these kind of petitions before the court?
Lord, I am coming to that, my lord. The only request is, my lord, why we filed this petition is because they were of a marriageable age and one of them has got married. And, my lord, the entire burden of the marriage, Lord, was on the mother.
Oh, why did you not think about all this?
Lord, but that was, my lord, in 2013, my lord.
But because the full and final settlement, you should have thought about all these things. And marriage expenses and all are not part of 125 CRPC.
Lord, but my lord, at least, my lord, some limited expense of the marriage, my lord, because both
that you
daughters
cannot
are there.
have under
In fact, the
125.
elder, sorry, Lord.
Under 125 marriage expenses from which provision it is there?
Lord, as a father, my lord,
That you cannot ask. Look at 125 CRPC. Are you entitled to that for a marriage expenses? Look at it. Please read 125.
And now, my lord, both are working, Lord. And one of the.
My lord, insofar as working, my lord, I have taken instruction.
No, 125.
Please,
read.
I am permitted to read that. Order for maintenance of wives, children, and parents. If any person.
It starts with its maintenance.
Please, Lord. Please. If any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, or his legitimate or illegitimate minor children, whether married or not, unable to maintain itself, his legitimate or illegitimate child, not being a married daughter, who has attained majority, where such child is, by reason of any physical or mental abnormality or injury, unable to maintain itself, or his father or mother, unable to maintain himself or herself, a magistrate of first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for maintenance of his wife or such child, father, mother, and at such monthly rate, as such magistrate thinks fit, and pay the same to such person as the magistrate may from time to time direct.
So your marriage expenses will not, all of them will not form part of 125 proceedings. Number one. Number two, there is a compromise. And there is no sanctity for a compromise then.
My lord, we are not claiming any other expense, my lord. In the compromise also, my lord, initially the
It is a
maintenance
full
of
and
wife,
final settlement,
the
means all
children's
the,
education.
all the disputes between the parties you have decided to put an end to it. And that apart, now if you say that marriage expenses, all the more reason that you are not entitled for any relief under 125.
My lord, 10 years have passed by, my lord, your lordships are aware.
No,
Insofar
no.
as their jobs are concerned, my lord, both are working in private institution, 10,000 rupees is their salary. And now, my lord, not on that. Only insofar as marriage, my lord, if you could contribute something, it is girl, my lord, child.
If he wants to contribute, let him contribute. Court cannot
That
tell
is
that.
the only request that we are making, my lord. Nearly, my lord, I am told, my lord, they have spent 15 lakh rupees.
You are again married?
Yes, I am
Yes.
married and I have a child.
Just put a word to your client, like give him whether he is ready to pay anything towards their, marriage expenses. Being a father, it's a moral obligation.
Please, I'll put a word on.
Then counsel of the petitioner shall get instructions. What is the amount the husband is ready, the father is ready to pay.
Or let them make out a figure, my lord, so that
I will ask.
Just communicate with him.
Please.
Yes. List this matter on 19th? Yes.
75. And
Yes.
My lord, other things not appearing.
No representation for the respondent. List this matter tomorrow as part one.
Lordship, on submission.
Huh?
Both the parties are willing to come
They're living together.
here. They are willing to come here to settle the issue in respect of maintenance. If your lordship permits me next week in the chamber.
List this matter on 26th November. Both the parties are directed to inform the other side also.
Please, madam.
Both the parties are directed to appear before the court in the chambers at 2:30. Yes.
Please.
Mm.
26 minutes.
November at 2:30. Not 2:30, 2 o'clock.
26. Please.
Yes.
In case of matrimonial discord resulting in filing of petition for divorce by the husband and as a counter petition for maintenance by the wife. And during the course of proceedings when the matter for maintenance was being heard, the wife files an affidavit, swearing to certain details, wherein she claims that she has no income, whereas it turns out that she is well employed and gainfully employed. This was the counter presented by the husband. The trial court, without referring to any of these things, proceeds to order maintenance of ₹7,500 per month. At that time, he was unemployed. Thereafter, he has gained employment also. But by virtue of the interim order, it is stayed. Now, the matter, both the divorce petition presented by the husband and the maintenance petition are set down for recording of evidence. In divorce petition, evidence is already halfway recorded. The maintenance petition, she has presented her evidence on affidavit. And this is the stage before the trial court, my lord. And because she swears to a false affidavit and makes a false declaration, I objected for grant of maintenance. But the trial court, when it was hearing the matter for settlement, the records are finding that no settlement could be arrived at, therefore, he is liable to pay the maintenance.
Heard the counsel for the petitioner in part. No representation for the respondent. Wakalat is not filed.
No, she has been served, she has remained absent.
We'll hear it then. Yes, let's go to the order.
Lord, we'll find this impugned order on page number 20.
22. Please read.
Yes. These two cases are set down on this day for reporting of progress of proposed compromise. Shri so-and-so does prefer MC number so-and-so as against Srimati Spurti, his wife seeking the relief of divorce on the ground of cruelty and desertion. Whereas the wife, Srimati so-and-so, prefers criminal misdemeanors number 327 of 22. Since last two dates of hearing, the learned counsels for parties hereto on record having put in their efforts, enabling the parties to go in for a compromise as there is no scope for their union. In continuation of such efforts, the learned counsel for Srimati so-and-so mentioned on the last day of hearing that certain jewelry items belonging to parties hereto are kept in safety locker of joint account, that Srimati so-and-so does need the jewelry items which belong to her, and that she is ready and willing to give consent for the jewelry items of Sri so-and-so, enabling him to continue them to possess. Besides, it was also submitted that Srimati so-and-so does need the expenses incurred by her parents for the marriage. That so far as the earlier proposal vis-a-vis jewelry items are concerned, this court called upon Srimati so-and-so to prepare the list of undisputed golden ornaments and to hand over the same to Sri so-and-so, so that after going through this such list, Sri so-and-so can give consent in respect of those undisputed jewelry items. Accordingly, list of alleged items were prepared and copy of the same was given to Sri so-and-so on last day of appearing. That on this day, the GSRK advocate files Wakalatnama and I under section 13 of Family Court Act with NOC to appear along with so-and-so. In the ends of equity, the IA is allowed. The court permits the counsel so-and-so to appear along with Sri KMC for Sri appeal. The GSRK advocate submits that the list as prepared by Srimati so-and-so is utterly
Where are
false.
your objections?
My lord,
Where are your objections?
Lord, kindly come to page number 42.
42. The instructions. Huh? Learned counsel for the, what is your name? Please write, she so-and-so submits that he has instructions to appear on behalf of the respondents. Learned counsel for the petitions to serve a copy of the petition on the counsel for the respondent. Print the name of so-and-so. List this matter on 25th. 25th.
Yes.
Number 79. With Shiva, Mirabai.
No, sir. An eviction proceedings were initiated by the respondent on the ground that he has purchased the property and a tenant. Eviction order is passed. Must I file a revision before the...
We will have it tomorrow as part for counsel for the respondent is not. Counsel for the petitioner is present, no representation for the respondent, heard in part. Post this matter tomorrow as...
Interim order mechanism.
Post this matter as part for tomorrow. Interim order earlier granted is extended till then. Yes, next.
Mediation, Section 81. Anand Kumar Shekhar. Santosh Kumar Lord.
Vice petition, my lord, seeking enhancement of interim maintenance.
How much is granted?
8,000 is granted. His salary is 75,000 per month, my lord. He is working department.
Heard the counsel for the petitioner, no representation for the respondents. List this matter as ready.
Next week, any date to watch.
List this matter as part heard on 14th.
Please. Great.
Yes. No representation on behalf of either of the parties. List is marked up for dismissal tomorrow. Yes.
Adjournments. Number 83, Proceedings, Region 9.
Seems worse. Today, my learned brother's lord's father is expired. It's,
When?
today,
No. Then when the
it's after 17 minutes, it seems worse. Post the
list is marked on 25th.
Please.
At the request of non-cox for the respondent.
Number 84, yes part. Yes, person part.
Petitioners, Your Lordship, this present petition is referred by the defendants number 1 to 7 here in Your Lordship.
What is 7?
1 to 7, Your Lordship. The present petition is preferred by the defendant number 1 to 7, Your Lordship. The plaintiff has instituted a suit for declaration and injunction, Your Lordship. The fact of the case is that, Your Lordship, plaintiff claims to be the founder of a trust, Your Lordship. This trust is entrusted with the job of running colleges and schools in the districts of the district of Belgaum and Saudati, Your Lordship. So the main allegation of the plaintiff is that, Your Lordship, when he was in the leave in the year in between 2015 to 16, there were 3 different resolutions passed by the other members, the defendants, that he was evicted from his post as a founder, and there was an amendment incorporated in the trust deed, Your Lordship. So now, by virtue of instituting this suit, Your Lordship, he is now seeking the suit for declaration as well as injunction, Your Lordship. By declaring those 3 resolutions.
What is the injunction you are seeking?
That the defendant number 1 to 7 be restrained from working as in trustees of this trust, Your Lordship. This is the prayer of the plaintiff, Your Lordship, a respondent, Your Lordship. What has happened?
Then if they are restrained from working as trustees, then who will work?
Your Lordship, the contention of the respondent is that, Your Lordship, it is he who is entrusted with running of this.
You also admit the fact that long back you have been removed from that post.
Not me, Your Lordship. It is the respondent, Your Lordship. I am there as another trustees, Your Lordship. The trustees who have brought in the amendments.
Please come to that IA.
Yes.
Where
Page
is
number
that?
52, Your Lordship.
50?
52, Your Lordship. The accompanying affidavit is at page number 53, Your Lordship. The very contention of the petitioner's hearing is that, Your Lordship, the suit which he has instituted by the respondent is not maintainable. Preferred a suit under section 92 of the CPC, Your Lordship. Since he is now asking the Honorable Court to settle a scheme for running the trust, Your Lordship, so the suit in the normal.
Before that, let's look at the plaint. Where is the plaint?
Plaint is at page number 12, Your Lordship. 10, Your Lordship. It starts at 10. The prayers are at page number 16, Your Lordship, and 7. The first prayer is that the 3 resolutions be declared as null and void. Consecutive prayer is that, Your Lordship, that the defendant number 1 to 7 be restrained from interfering, causing interference or obstruction to the plaintiff or the chairman founder, Your Lordship. These are the 2 prayers sought by the respondent here.
It's a public trust.
It's a public trust, Your Lordship.
Is it a public trust?
It's a public trust, Your Lordship. This trust has been incorporated only with the purpose of running schools and colleges in the district of Belgaum, that is in and around of Saudati, Your Lordship. It is also admitted at page number 12, Your Lordship, in the paragraph number 1, the purpose of this trust, Your Lordship. Initially, Your Lordship, when this suit was instituted, the Honorable Trial Court dismissed the suit by holding that it is not having the jurisdiction to try the suit, Your Lordship. He then preferred an appeal before the Honorable District Court, and the suit came to be restored. Subsequent to the restoration of the suit, Your Lordship, the notices were issued to the defendants of the petitioner's hearing. Then we have filed a detailed objection as well as application to reject the plaint, Your Lordship. Honorable Trial Court on erroneous grounds has rejected the application preferred by the petitioners. So we are here before this Honorable Court, Your Lordship.
No. What was the earlier order?
Earlier order was that, Your Lordship. It is forthcoming in the page number 22, Your Lordship. It says that the suit is not maintainable. The present suit preferred by the respondent number 1 is not maintainable since it is not maintainable and it is not triable before the Honorable Trial Court. Against this order, Your Lordship, he prefers a miscellaneous appeal before the Honorable District Court, which is forthcoming at page number 23, Your Lordship.
So now in the similar lines, you want the plaint to be rejected?
Your Lordship, the thing is, what the suit is instituted and what the relief he is claiming for.
But already, a district court has already held that the suit is maintainable. In MA,
That is on erroneous grounds, Your Lordship. It is,
which you are questioning. You are
Yes,
not
sir.
questioning that order.
That
at
is the
all.
order. We are questioning the order, Your Lordship. After this,
There are two things.
Yes, Your Lordship.
One is, even if you come into picture,
Yes.
a district court held that the suit is maintainable.
When that appeal was preferred, Your Lordship, we were not party to
Correct.
it. Yes, sir.
Now you have filed this application before the lower court.
After the suit was restored, Your Lordship, when summons were issued to us.
Now, can the court give a finding contrary to what the appellate court has given?
But that is the
But your grounds are also similar grounds.
Yes, Your Lordship. It's also on
Then
the
what are you supposed to do? You cannot. How can the judge grant a different order now?
Your Lordship,
When already there is a finding by an appellate court that the suit is maintainable, how will he say that no, the suit is not maintainable?
But Your Lordship, the nature.
Whether you are there or not,
Yes, Your Lordship.
you are there or not on record,
That
but
is-
the order will not alter.
That is there, Your Lordship. But the nature of the relief he is claiming, Your Lordship, they do not
No,
fall
that
within-
is a secondary aspect. Now, what would you, now you are before this court,
Yes, Your
as far as the trial court order is concerned.
Yes, Your
That the trial court, can it take a contra view than what has been taken on an appellate court?
But trial court ought to have taken the objections raised by the defendants, Your
It's
Lordship.
already decided.
Because that
And that has attained finality.
that has not been taken into proper, it has not been properly appreciated, Your Lordship.
Let's see the trial court's order.
It is forthcoming in the page number 58. Of the
Page
petition.
number?
Page number 58, Annexure G.
58 or 68?
58, Your Lordship. The improved order, Annexure G. Your Lordship.
Please come to the reasoning part.
Reasoning part is that paragraph number 10, 11 and these paragraphs here also.
Come to paragraph 12.
Yes, sir. What has the trial court held is that, Your Lordship, if the individual or any person who has filed suit, if he is seeking declaration of his individual right or in his individual capacity, then the suit under section 92 is not maintainable, Your Lordship. This is a reasoning given by the Honorable Trial Court for rejecting the application filed by the petitioner's hearing.
Para 14.
Yes, sir.
Read.
Further, careful perusal of the order passed by the Honorable Senior Civil Judge Saudati in miscellaneous appeal. So it has held that the present suit is not come within the purview of section 92 of CPC and also directed the principal civil judge and JMLC Saudati to take cognizance of the suit and proceed with the adjudication of the same in accordance with law. Accordingly, the suit was made over to this court for the adjudication. Defendants have not placed any document before this court to show that they have challenged the aforesaid order by judging the factual matter.
That's precisely that's what this court is also saying.
Yes, Your
You have
Lordship.
to question that order.
But Your Lordship,
As on you're a party to that, see, leave out. You can question that order.
But the very fact is that, Your Lordship.
No, please understand. How can an appellate court has decided and remanded the matter
Yes, Your
and held that it is maintainable? How can the learned judge give another finding on the same aspect?
Your Lordship, may I just say some instructions on this, Your Lordship?
Yes.
And I think this is-
This is matter when?
Friday,
Further counsel in part, Mrs. Matter on Friday.
March of that.
Yes, Partner. Yes, next.
Each party.
Please, wife's petition must have it as a, for wife it is dismissed, my lords, and for the child, they are ordered 2,500.
2,500. For wife, why it is dismissed?
My lord, stating the reasons given are, my lord, she is staying with her, in her house, means she is staying with the parents. So for the accommodation, she need not be paid.
And what about, apart from accommodation, what about the maintenance?
No, that they are not explained.
That, the parents will take care. That's what the finding.
Yes.
Let's see that. Please come to
At
that.
page number 18, my lords, of the judgment, 24, my lords.
24.
24, my lords. That is para N, my lords, from the second line. From the top, my lords. On admitted fact that the petitioners are residing at the matrimonial.
Are you reading it?
From the top, my lords.
An admitted fact.
Please. An admitted fact that the petitioners are residing at the matrimonial house of the first petitioner, as such, they do not require any amount towards accommodation. As already observed, the petitioners have failed to prove that the first petitioner has refused to reside with the respondent without sufficient cause. Further, the first petitioner is having income of her own by tailoring. Further, the petitioners have failed to prove that respondent is having sufficient income. Hence, the first petitioner is not entitled for any maintenance. The respondent is duty bound to maintain the second petitioner since the second petitioner is residing with his mother. It can be presumed.
What is the income of the respondent?
Lords, they have shown after cutting everything, it is 8,000. He is a KSRTC driver, lords. They will be driving more than 40,000 minimum, lords, with experience.
The document is produced R4 models. His salary certificate is produced. Additional models, net salary is models 8,965.
You are not a permanent driver. You are on a contractual basis.
Yeah, that's permanent. Or the permanent KSRTC drivers they are not permanent. That's only that is.
Even till now your salary is 8,000.
8,900. Document is produced. Exhibit R4. R4 document is produced.
After cutting all the salary, they have taken one yearly certificate. In that festival, they have cut some yearly 14 to 15,000.
Place before the court your present salary certificate.
Total grass salary is 14,000, and after net models 8,000 is shown as that exhibit R4 models. Or the document has produced before the court.
What are the cuttings of 8,000?
Sorry.
What are the components?
It's a permanent job, my lords. KSRTC drivers are permanent job. It's a government job.
Any matrimonial cases are pending?
No, my lords. But the specific contention taken by the wife there, my lords, that he is having an affair with one married lady, my lords. So that has been given in reply also, my lords. In the notice reply, she has given the reply, my lords.
What is this HBL SOC? Towards that, there is a deduction of 4,877.
Even, my lords, for festival advance 6,500. No one will deduct every month, my lords, 6,500. I think it may be yearly or, my lords,
sorry. File the salary slip of your client for the month where there is no festival.
Please.
The salary slip of the respondent shall be placed before this court. This is matter on 19th. Yes.
In the meanwhile, we have seek mediation if any.
Yes.
Sir, it becomes already diverse, my lord. Diverse is granted, my lord. Then prayatna ಮಾಡ್ತಾರೆ, let's try. They are interested.
Matter is coming up on 19th. Appear for mediation on 14th.
Please.
All the parties are directed to appear before the mediation center on 14th of November. 14th.
14. Before this one.
Mediation center.
Here.
Here it may be listed on 19th, my lord, in Pakad.
It will come on 19th. 14th you go there. You come back on 19th.
Mediation center at Dharwad, High Court.
Dharwad.
High Court.
Mediation center next to the High Court. Yes. Yes.
Please, my lord, 86, my lord. My name was shown wrongly in the cause list. Yesterday also I was not, on that matter of 3 steps, I was not present for this court, my lord. It has to be Girish B, but registered shown as Girish A, but on some occasions I was not present in the matter.
Bring the name of the counsel for the respondent as
Girish B.
Girish B. Bhatt tomorrow.
It's my last time, my lord. I have gone through the papers, my lord. Yesterday my colleague has informed me that matter is listed.
You are ready now?
Please, I am ready.
Give the.
My lords, one bit, connecting of matter, criminal petition regarding the same issue. They have filed a domestic violence case against us in the trial court, and we have challenged the same. And the domestic violence was ordered before the filing of the maintenance matter. And in the said the domestic violence, they have already gotten the interim
maintenance order.
Maintenance was ordered, my lord, of 8,000 rupees. And later, when we challenged it, it was reduced down to 5,000. And after the reducing of 5,000, my lords, they have filed a maintenance suit. And so it is requested to connect them up.
No. How can it be? If it's a criminal petition, it will be.
My lords, there are consecutive.
Let it be decided. It has nothing to do. Any relief under the Domestic Violence Act is in addition to the reliefs that are available to the parties.
My lords, at the same time, we have to pay both the money. Both the.
So that we will take into consideration. Now it is 5,000 he is paying. So looking at what is this petition, what is that your
No, my lord,
salary?
They have claimed the recovery suit for 8,000 rupees per month, including 11 months for 3 years. And they have already paid rupees.
The counsel for the petitioner submits that between the same parties, the maintenance was granted the Domestic Violence Act, and the same is questioned by filing.
Please, criminal appeal.
Criminal appeal.
Criminal petition. In appeal it was granted as 5,000.
Criminal petition number. Write on a paper and give. Criminal petition number so and so. He submits considering the same. The registry is directed to post both the matters after obtaining necessary orders from the Honorable Chief Justice. Yes, next.
But if my lordship permit, in that, as per my knowledge, my lord, in the criminal petition, they have challenged the very proceeding itself, not the maintenance. So if it is listed for my
that must be the maintenance, not the proceedings.
My lord,
We'll see.
Please,
If it has nothing to do, we will again. Yes, 87.
This one.
14th. Yes.
Please, my lord.
Petition. The maintenance of 5,000 has been awarded. But and to recover the same lot, the respondent wife.
There is no representation for the respondents.
Thank you, madam. Yes.
Yes. What is the maintenance granted?
So 5,000 has been awarded. In order to recover the set, not the respondent wife filed the recovery proceedings. In the recovery proceedings, not the matter of settlement. May I have page number? 48, madam, of the order sheet of the recovery proceedings note. So the order dated 9/8/2021, page number 48. Petitioner and respondent present, both parties agreed to settle their disputes amicably. Hence, office to report the same. Parties agreed to rise together. Call on to report 14th August. No. Next page, note 50. The parties have settled the matter as per the advice of the council's members so and well-wishers and elders of their family. The parties have made their decisions before the local law, already noted on 9/8/2021. Is recorded on this day. So and so. What is this?
Where is that?
Please.
What is the settlement?
So that is not the.
How can the court be so irresponsible? If there is a settlement, settlement should be there. What is the settlement? Joint memo shall be provided. Where is the joint memo? What is this kind of recording? Which court is this?
Family court, my lord, Kalari.
Very strange.
My lord, thereafter note, he has taken note with the exponent wife. He has taken note separate rented house note. I stated that I will not stay in Gangavati. I will stay in Ballari note. There he has taken a house on rent and not he used to pay the rent and also the all expenditures of the day-to-day expenditures, etc. And since he working in a rice mill in the Gangavati, he used to go up and down. And thereafter, in the year 2022, she filed present proceedings under section 125(3) to recover the arrears of maintenance since from 2018 in a single petition. That is not maintainable.
Why not maintainable?
Because lots of kindly say provision to section 125(3). May I read it?
That more than a year it cannot be recovered.
Please,
There is that order. Order. I asked you to keep that order. वो है ना उस दिन ये लेके आए थे ना आपको हम सर्टिफिकेट से एक रिकॉर्ड दिए ना आपके वाला करके कि लिखा रखे हो
And during that period, he has paid him this amount through by hand.
You can say that this is the amount paid by me, and without deducting that, the wife had claimed it. But you cannot say that it is not maintainable. It is maintainable.
You cannot maintain it.
Not the provision. There is a judgment of the Supreme Court.
And along with memo, I have also produced a document that is amount paid through Google Pay notes, screenshots note.
That's why please do one thing. As far as the maintainability aspect is concerned, that's not open to you. It is maintainable. All that 1 year and all that's the order of the Supreme Court. Then what you have to do is, what is that she claimed? What is that you paid? File a calculation memo before this court. Then the court will look into it. And if you have already paid and she is claiming it, then we will deduct that amount.
And the allegation about that I have not taken care that possible because I also paid the amount.
Those are all not necessary.
Continuously paying
If you have paid, show it. What is that you have paid? File a calculation memo before this court.
Please, I will file.
Like calls for the petition.
Submission, my lord. For the period 15/11/2018 to 15/9/2022. That's the arrears to be paid.
Both the parties shall file their respective calculation memos before this court by 20th of November. This is matter on 20th. Yes.
Please. My lord. Please, on behalf of Ganpati Bhatt. My lord, sir, this petition is from the mother of the deceased, my lord, deceased husband. Ex-party order was passed, my lord, sir.
What is that? Who is the petitioner?
Petitioner is the mother of the husband, my lord. Husband died, my lord, sir, after ex-party order was passed against the wife, my lord. Thereafter,
who has filed the petition?
Petition is by one Divakar, his husband of the respondent. He filed his, my lord's, petition for dissolution of my lord's marriage. That came to be decreed in the year 2015. I take page number 1, my lords, page number 1 of the petition. Then thereafter, my lords, after knowing that my lord's wife has staying some my lords in Shimoga district. Thereafter, after death of the my lords, the husband of the my lords, the respondent, she filed an application for my lords
setting aside the ex parte decree. That came to be allowed. That came to be allowed. Thereafter, my lord's mother has filed an application for LR application of the deceased son. That came to be rejected, relying on judgment of the Honorable Supreme Court in the case of my lord's Yellava versus Shantam. Now, to kindly see the impugned order for a moment, my lords, please to see in page number 82. Sorry, 81. May I read from 81, my lords?
Where the Supreme Court said if it is the people who are concerned with the estate of the person can come on record.
My lords, this is the learned trial court has observed, the family court has observed that the rights which are involved in this case are the private rights that cannot be decided. It pertains to only between husband and wife.
A decree is granted.
Decree is granted.
Now, by virtue of this,
yes.
Now if it is restored,
yes.
She is a wife of
she becomes the
wife of the deceased.
Yes.
Once she becomes the wife of the deceased,
yes.
Then all other issues will come in. Her entitlement about so many issues and all. And then, had it not been there, yes. So and so must have inherited the property or other rights.
Yes.
Now, by virtue of this order, their rights are also going to be affected.
Issue involved in this case also the same, my lords. With respect to my lords, Shantava versus Yellava versus Shantava case. My lords, here it's a case that their civil rights can be decided, my lords, elsewhere in the suits, my lords, with respect of their property is concerned. As far as status of husband and wife, that can be legislated only by the, my lords, concerned parties. The mother of the deceased son.
If I remember correctly, there is a judgment saying that
Please.
it's not just about, even after the death of the person also, still that cause of action continues where it involves any other rights.
Even divorced wife, she can maintain, she can file a petition for her maintenance even after death of her husband against the estate of the husband. To that extent, she has a right, even after death also.
No. For setting aside the order of ex parte order of divorce, that's it. That there is a judgment. Where is that judgment of the Supreme Court? What is the citation?
Citation in page number 81 in the Mallards. 81 page. Para 14 minutes married.
Citation is not
citation, entire citation, only observation is recorded.
Rita De versus Chandana Kumar De. RATK. No. Yellava versus Shantapa. Get the judgment. Let's read the finding.
Please.
Whatever the extract that you please read.
Please, the in page number 82. I read from the in page number 14, minutes, part of convenience. The facts of the case of law of Srimati Yellava versus Shantava are that Sri Basappa, son of Srimati Yellava and husband of Srimati Shantava, had obtained ex parte judgment and decree of dissolution of marriage of Basappa and Shantava. The subsequent thereto, the said Basappa died. Thereafter, Shantava moved an appeal. The said appeal was seriously contested by Yellava by filing the petition under Order 22 Rule 4 of CPC in the appeal preferred by the Shantava. That after hearing the parties of the case, the Honorable Appeals Court has inter-alia made the following observation. Now remains the question as to whether the proceedings for divorce as restored by the High Court by its impugned order and required to be proceeded further or the curtain must be dropped on the said proceedings as the ex parte decree is found to be rightly set aside by the High Court. The marriage petition would automatically stand restored on the file of the learned trial judge at the stage prior to that at which they stood when the proceedings got intercepted by the ex parte decree. Once that happens, it becomes obvious that the original petitioner seeking the decree of divorce against the wife being no longer available to pursue the proceedings now, the proceedings will certainly assume the character of personal cause of action for the deceased husband and there being a decree culminating into crystallized rights and obligation of their spouse. The said proceedings would obviously stand abated on the ground that the right to sue would not survive for the other heirs of the deceased husband, not certainly other heirs of the husband, to get any decree of divorce against the wife, as the marriage tie has already stood resolved by the death of the husband. No action, therefore, survives for the court to snap such a non-existing tie. Otherwise, it would be like tying to slay to the slain. As this stage, there remains no marriage to be dissolved by any decree of divorce. Consequently, now that the ex parte decree is set aside, no useful purpose will be served by the directing the trial court to proceed with the Hindu marriage petition by restoring it to its file. The Hindu marriage petition number so and so moved by the Sri Basappa, the husband of the respondent, on the file of the court of so and so, will treated to have abated and shall stand disposed of as infructuous. The appeal disposed of accordingly. In the facts and circumstances of this, there will be no order as to cast. This is observation made in the case of Yellava versus Shantava. That's the decree of divorce is being the Mallard's personal right. And Mallard's setting aside of that is also by the Mallard's.
I've seen some law like that.
Annexure J is the Mallard's the order passed by the learned trial court in setting aside the ex parte order. And Annexure M, this which I have read, Mallard's, is the application filed by the Mallard's mother of the deceased Divakara, husband of the Mallard's, this respondent, for bringing LRs on record. Mallard's, no purpose would be served.
Will you appear for the?
I appear for the wife. Please.
Husband has got an ex parte decree of divorce. Now, why the wife has to get it set aside? What is the purpose? If the same analogy, what you are saying has to be put in. So why it should be done?
Mallard's wife had
if it is if according to you, if it is a personal this thing and the ties have come down, nothing to be done, then you shouldn't have been restored. If that same analogy is applied to you also.
Yes.
After the husband's death, why should that ex parte order be set aside?
Case on hand in that case, the same thing has happened, Mallard's. The wife has filed the application for setting aside expired after death of the husband itself.
No, what will happen now? No, husband is no more.
Yes, husband is no more.
Then who will contest? No, what is that the court is relying for your...
Would be even
No, there is a distinction in that. Well, let's just see. The court has failed to record the further paragraphs. This is where you fall. Similarly, if an ex parte decree of divorce is obtained against the wife, and thereafter, if the husband dies, the aggrieved wife can maintain an application under Order 9, Rule 13 CPC, even though the husband might have died prior to the moving of that application or during the pendency of such application. In all such cases, other legal heirs of the deceased husband can be brought on record as opponents or respondents in such proceedings by the aggrieved spouse who wants such a decree to be set aside, and when the other sides of the deceased husband would naturally be interested in getting such a decree confirmed either in appeal or under ordinance so and so. The second alternative contention so and so, therefore stands rejected.
In my application, I have brought the my lords the petitioner herein as a legal heir of the my lords the deceased husband. That application came to be allowed.
Yes, please come to the implement order.
Submission, Milords. I will go through this judgment, Milords, which the trial court has applied. I don't have the judgment, Milords. Because after the death of Milords, of the husband.
You know, it is like this.
Please.
What the court says is,
Please.
in that, it's the only either the wife or the husband can file an application to set aside the ex parte decree
Yes.
or order, whatever is granted.
Yes, Milords.
But the remaining family members,
Yes.
they have no right to come in.
But Milords, here Milords, what has happened? First, the ex parte order is set aside, Milords. Now it is abated. Milords, because Milords only as for reading, Milords, I have not gone through that. Judgment,
Go
Milords.
through that.
Yes, yes.
Day after,
Yes, please.
this is matter day after tomorrow. At the request of the counsel this morning.
Because after the death of Milords, 2015 is a judgment. 2020
No,
dies,
no,
Milords.
but still,
Yes.
that's what you can understand reading the
Please, I will go through that. Milords.
Yes.
Petition filed by the husband, challenging the section 12 proceeding, under section 12 of the Domestic Violence Act, the wife has filed the application, for before the GNFC, in that, two daughters were there from their wedlock. 2000 each inter-maintenance was awarded. The husband is regularly paying the same. The husband as well as wife are the government teachers, she filed section 12 application, making all the family members were parties, that too filed in the Baido Hongala court jurisdiction, that is in Belagavi district, the petitioner and the respondent were residents of Bhatgal in Uttar Kannada district, they are coming under this jurisdiction, but the distance between the Bhatgal to Bailongal is more than 200 kilometers.
What is the impute order?
The entire proceeding under section 12, is challenged by the petitioners, on the ground that, in Bailongala court has no jurisdiction to entertain the petition filed by the wife. Because she is serving a teacher, as a government teacher. She never resided in the Bailongala court jurisdiction, Though, section 27 of the Domestic Violence Act, stipulates permanently or temporarily. But
This petition is filed on the file of which court? Family court?
yes,
No.
Bailongal court, Bailongal court,
That's what. Then how about petition is filed? That I'm not able to understand.
For that, earlier criminal petition was filed, that is withdrawn, because of the Kolkata High Court judgment, the proceeding under the Domestic Violence Act is a civil, quasi-civil in nature, so 482 is not maintainable, For that reason, the petition is.
How it is maintainable? How it petition is maintainable?
Because, the proceeding.
No. Arising under what proceedings? Now, this court is having roster of family court matters.
Yes.
And the interlocutory applications arising out of it. So, how is it one of that nature?
Yeah, I understand, but this is filed before the Principal Civil Judge and JMFC Bailongal, Annexure F is the earlier 482 order, this honorable court, because of the Kolkata High Court judgment, 482 is not maintainable, that was the.
482 is not maintainable.
How?
How 227 writ petition before this court is maintainable? That you tell the court.
For that,
It is not a 226 jurisdiction that when you have
Yes,
no other
yes,
alternative
yes,
empty,
yes,
you will come under our 226. You are under 227.
Yes. For that, my submission is any vexatious proceeding, because the section 12 application is filed by the wife, Domestic Violence Act, gives a right to the wife.
First of all, this court should have jurisdiction to.
Yes, because of earlier I filed.
What is the roster of this court?
But because of wrong classification,
Then let it go. This is, he has questioned proceedings initiated before the JMFC Balhongan. The history is this is not arising out of a family court. The registry shall clarify how this is numbered as a FC petition.
Please.
Yes. Yes, next.
Earlier, my lord, RS, GM RS, I returned GM RS also, but we have.
Still number 19. Finalizing, still number 91. Formula.
Suit for declaration and the possession came to be concurrently declared. Suit for declaration and the possession came to be concurrently declared. Thereafter, my lord, the execution petition was treated. It came to be dismissed on the ground that I am seeking the possession more than what is visible in the sale deed. I purchased the suit property. The execution petition.
Where is the decree? No, where is the decree?
Earlier records were got.
Yes, court officer. Look at it. Where is the decree passed by the court?
Be on the ground that I'm seeking the area more than what is shown.
So that's what is granted will be given.
Please.
Black title, roofed house bearing its TMC number, situated at so and so, within the limits of Samno. Another black tile roofed house, ward number 3, block number 2, so and so, situated at Juma Nagar, consisting of 3 parts and totally measuring. Please come to the order now.
Lord, page number 19 of my petition.
Page number?
19. Paragraph number 12.
Yes, please read.
Please, the sale deed produced by the decree holder, that is Exhibit P6, is clearly reveals that the decree holder had taken the possession of the suit property or property mentioned in the sale deed on the date of its execution itself. It means that the decree holder had obtained the possession of the property mentioned in the sale deed on the date of its execution. The Exhibit P9 further reveals that the property number 131, Ward 3, Block 2 is totally measuring east-west 51, north-south 45 feet in the extent east-west 10 feet and north-west 12 feet was a brick tile house. On the perusal of the petition, the government is not disclosing the measurement shown in the Exhibit P9. In other words, the measurement mentioned in the petition is not at all matching to the measurement mentioned in the sale deed or in the Exhibit P9. The PW1 has admitted in the cross-examination that he had purchased the exhibit east-west 27, north-south 31 in the property number 131, except to the extent he had not purchased any extent of property. PW1 further admitted that ನಾನು ಖರೀದಿ ಮಾಡಲಾದ ಆಸ್ತಿಗಳನ್ನು 10 ಬಾರಿ 12 ಒಟ್ಟು 120 ಚದರಡಿ ಇರುತ್ತದೆ. The version of the PW1 has not corroborated with the documentary evidence. The PW1 further admitted that he does not know what were all happened in the original so and so. Because I purchased it in the RML, I substituted the appellate, the respondent in the the PW1 further admitted that he had obtained the power of attorney from the plaintiff in the so and so by giving assurance to the recovery, the recovery of the possession of the property and on the same strength or on the same manner he had declared in the RA 77.
As I mentioned above, the recitals of the exhibit P9 is clearly goes to show the degree holder had obtained the possession of the property mentioned in the same day on the date of its execution, and also the measurement mentioned in the petition is not at all compared to the extent mentioned in the same deed or exhibit P9.
No, it is a finding of the court that you have already taken position.
No,
And you have filed for execution.
No, that's a constructive possession. Ivattu now kabja korta ide that is what usually mentioned in the same deed is what they are mentioning. But the actual possession, to have just a flashback of the case, my lord. Essentially, the matter, the property belonged to some family called as Manier family.
What is the suit for?
Suit for declaration and the recovery of the possession. Just a brief one, my lord. So far as this matter of a possession.
So what is this finding of the court?
No,
when the
because-
suit is for
Yes, my only-
declaration and recovery of possession. That means he's saying that the possession is not with him.
Yes, my lord, during the pendency of the appeal, he purchased some portion of the property in the 131, that is renumbered as 108, is renumbered as 131. He purchased some portion of the property, that is exhibit P9. He substituted to my lord in the place of original owner. Thereafter, my lord, evidence was led, inquiry was sought by the executing court. He has admitted that my lord, he has purchased only 10 into 12, that is 120 ಚದರ ಅಡಿ ಇರುತ್ತದೆ ಅಂದರೆ ಸರಿ, ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿ, not more than that. And my lord, he has not filed any application. My lord, if you want to claim more than what he has purchased, he has to seek a declaration, or he could have filed an application.
Court is there to execute the decree.
Yes, my lord. Therefore, my lord, the original owner is not made a party in the execution petition. That original owner, that is the one, my lord, for submission.
As per the whatever is the decree,
Yes, ma'am.
it has to be executed.
Executed by the original owner, not by the purchaser a portion of the property. Because he has purchased, my lord, according to, because the
Not the GPA.
Yes, ma'am.
Is the GPA of the original purchaser.
Yes, purchaser of
now
the.
he has stepped into the shoes of
Yes,
the
my lord,
purchaser.
only a purchaser of some portion, not the entire property. Therefore, he could have implemented the, my lord, the original owner to say that I have given entire property to him in the under the registered sale.
Forgetting about what he has purchased. Now, what is now is there is a decree staring at you. Is it not?
Yes.
So that has to be executed. Now, what is all this discussion? I'm not able to understand.
Yeah, my lord. Therefore, in that portion of my lord, the lordship just now read the, my lord, the decree, that is, my lord, the 3 portions. In that also, my lord, I have purchased, it is renumbered as 131 to 134. 132 to 133, 134, my lord,
Who are you?
judgment letters. Judgment letters are purchased under the registered sale deed. 132, 133, 134. So 130 in 131, my lord, totally measuring, my lord, in total extent, he has purchased, my lord, 120 square feet. That is.
No, he has purchased a property, he or his vendor.
Yes.
His GPA holder, his principal, whoever it is,
Yes.
he has purchased a property from you basing on a registered sale deed.
Yes.
Basing on a registered sale deed.
Yes.
So, as per that sale deed, as per that measurements, execution has to be done. The possession has to be given to him.
Yes.
What is the difficulty in that?
No, therefore, already possession is given to what he has purchased.
Who has given possession?
The vendor. Therefore, my lord, I will take the, my lord, I'll take the, my lord, I will read, my lord, the lordship, the documents are also before your lordship. My lord, the lordship, can you see the exhibit P9?
Para number 12 of the order, please read and
Yes,
tell
ma'am.
about what it is.
My lord. No, before that, my lord, I will take the, my lord, the para 10 hours. Because 8, my lord, the executing court has called out the, my lord, what he has admitted by the PW1 in Kannada version. My lord, he says that, my lord, ನಾನು ಖರೀದಿ ಮಾಡಲಾದ ವಿಸ್ತೀರ್ಣ 10 into 12 ಒಟ್ಟು 120 ಚದರ ಅಡಿ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. Not more than that. Exhibit P9, your lordship, kindly see the, my lord, because he has produced before the executing court and he has led the evidence. My lord, read, my lord, the witness examined by the judgment letter number 1B also supported the case of judgment letter number 1B in the chief examination. It is relevant to note that the DWT is none other than the judgment letter number 2C in this case. He has also denied the material suggestions of the decree holder counsel in the class examination.
On perusal of the materials on record, it is relevant to note that the judgment letter counsel much argued that the present decree holder has not power to initiate the present proceedings against the judgment letters. On perusal of the order of the Honorable Additional Senior Civil Judge Haveri in area number 72 of 2005, it discloses that in the line 4 of first page, first paragraph, that the rank of respondent number 1 as a plaintiff in trial court and during the pendency of appeal, one Muhammad Hanif purchased the suit property and is substituted in the place of the respondent number 1. Therefore, the decree holder herein having a power to initiate the proceedings.
This finding of Parrot, well, it's very ridiculous finding.
No. Therefore, my lord, if you want a clarity in that order, he has to implead the original owner. That is, my lord, calendar. Then, my lord, your lordship, let them implead, my lord. May I request, my lord?
Not impleading, please understand.
Yes,
You have supported a decree.
Yes, I
You have
support.
not questioned it. You have supported a decree and there are means and bounds to that.
Yes, my lord.
As per the decree, as it is, it has to be executed.
And therefore, my lord, we have produced the sale deeds. We have purchased the, my lord, the exhibit D1 to D2 before the executing court. My lord, we have purchased the, my lord, the 3 portions. And in 3 portions, we have purchased the 2 portions of the, my lord, the properties in question. 131 he says that, my lord, he purchased some portion. There is no specific, my lord, the boundaries. Therefore, he could have filed an application under 47, my lord, CPC to hold an inquiry, producing all these documents. I have produced, my lord, the sale deeds. He has produced the sale deeds, doesn't disclose the, my lord, the measurement.
No, when the decree is passed, which is affirmed by in the
Yes.
Have you stated so about all these things that the suit scheduled property is not what it is as it exists?
Yes, my lord, we have read the evidence, my lord, your lordship kindly see.
So, where is the question of leading the evidence in execution petition?
No, that is because of the question, my lord, they claim that the entire property, the entire extent of
He can claim the property as per the decree. First of all, both of you clarify the doubt of the court.
Yes.
What is the ambiguity between the decree and execution?
No, if your lordship's kind permission, may. My lord, if suppose, my lord, I have purchased, my lord, this is a suit property, the possession. My lord, if I purchase a particular portion of this property, then, my lord, he has to execute this portion. Remaining portion I have purchased. My lord, therefore, my lord, to clear the ambiguity, who has purchased what he has, and under whom he has purchased.
No, in the suit and the RA, you are a party.
Yes, my lord.
Court has given a finding with regard to the suit scheduled
No, we are not
property and the dimensions. You do not dispute any of it.
No,
You do
we
not
are
dispute any of it.
We are not disputing.
No, is it what you are saying is it can't be identified?
No, therefore, there is a, my lord, identification, my lord, problem. That is what I have purchased the 3 portions, what he has purchased the first portion. Therefore, my request, let them identify the property by the executing court, by appointing a surveyor or a commissioner.
First of all, these findings, everything should go. Sale deed contains that position is given.
Then,
What is all this?
May I request, remand the matter with a particular specific direction to the executing court to hold an identification of the properties. Identify the property, what I have purchased, I have put the exhibit as per the sale dates. Exhibit D1 to D2 I have purchased. As per the exhibit P9, my learned friend client is purchased. Let them identify the property, who has purchased with extent. There ends the matter, my lord. There is no ambiguity at all. It will be clear, my lord, once for all.
Firstly, my lord, admitted fact. I am the owner of 131 as my learned counterpart also.
No, 131 a portion. 10 by 12. That's all.
Due respect, let me submit. 131. He is the owner of 132, 133. Nowhere across the trial, OS, RA or here, nowhere he has said, I have trespassed in it. This is one factor. No sale deed. He has produced a sale deed of 132, 133, 134. Not at all with regard to 131, which I myself is the owner. First thing. Secondly, the only person who can challenge the area or the measurement or my titleship is none other than my seller. He has now been the picture. First point. Secondly, across the trial, in the OS, in the RA, in the execution petition note, the boundaries of the suit schedule property is very intact. One understand.
Well, when you have filed this EP, what are the objections filed by them to this petition?
No, this is a new objection that has come, which has never come in the OS or the RML. The thing is, they have been titled as illegal trespassers by the courts below. Somehow they want to continue the possession, and this is a spontaneous innovation ground. Because specifically the RF has used this word, illegal trespass. That's why I was beginning to make a submission with regard to the background of the case. I purchased the property in the year, my vendor purchased it in the 88. I purchased after the OS and then RM got substituted as the respondent. He was in the illegal possession. Original owner purchased Manta. He comes and purchase money, they go outstation. They reside in some Ranidilur. The property is situated as lordship in the suburb. They don't reside here. So somehow they illegally occupied.
All that compromise matter, I have a meeting at 4:45. All that compromise matter. Cross and paper. Yes.
So the respondents were the native of the village, the town, they illegally were occupied. Then I went and inquired after having purchased it. My vendor asked me, HRC Vadige Kotte. Then HRC proceedings were initiated. That got dismissed, saying that landlord and tenant relationship. Then my vendor was constrained to file this recovery position and they titled. Concurrently, the courts will have held. So they still want to continue the illegal possession. The boundaries are not settled position, the boundaries prevail over the area. And if at all, the executant court feels that there is a difference in the area, let the honorable executant court would have said that his right will be limited only to the extent of the sale date. Not outrightly dismissing my execution petition. It simply means that the illegal trespassers are giving the title to continue the illegal possession. That's a fruitless effort. When the OSM title confirm registered sale RIL confirm just on these technical grounds, if my rights are curtailed, then the illegal trespasser, declared illegal trespasser, will become an owner.
No, after this.
The Honorable Trial Court, my submission would have confirmed, at least saying that execution, suppose there is a discrepancy in the OSL road schedule and the RIL, sale date ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ನೀವು ಯೋಗ್ಯ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು would have been. Outrightly denying would vitiate my sale date, my decreeing entire.
This arises only. I purchased my land on 29/9/2009 after disposal of RA from the original owner, original vendor. My land 132.
When you purchased litigation.
No, not litigation. The other portions, there are three portions, not other portions. Because the registered sale deed, 29/9/2009, the 131, 132.
No, one thing is clear. First of all, this order of the court has to go. This has no basis. This discussion, not about all the. No, in a sale deed, if there is an averment saying that the possession is given and a suit is filed for declaration recovery of possession, can the court say that in the suit, the sale deed itself is there is a clause of possession? So there is a question of giving back possession. At para number 12. That observation is absurd observation.
That is there, but Malad, so far as
oppose this matter tomorrow as parted, will pass orders.
So far as Malad, our sale deeds are concerned, because exhibit D1, D2, Malad's.
Were you a contesting party before the court?
Contesting party, Malad. After that, all these were purchases only the vendor after Malad disposal
so
of party.
You are not a party before the.
Malad, all the OS and the regular.
No, you are saying that you purchased the property after the disposal of RA. So you have not contested the matter.
Contested the matter after disposal of RA and all proceedings. The original owner has alienated to some portion to him and 2-3 properties for him. For me, 132, 133, 134.
So where is the question of original owner again alienating the properties when there is a decree for him?
Not the decree for him, not the entire decree. Decree he has substituted on the ground that he has purchased the portion. Your Lordship kindly see the order of RA.
We'll see tomorrow.
Friday, come in Friday, may I request?
Oh, Friday.
Please, great.
There is a petition now.
We have received all the ornaments and amount also.
What's to come? First of all, ask it to come forward. You have received all the ornaments? Huh? All the ornaments are received. 4 lakh DD.
Check. Account page.
How can you give an account pay check? You have a DD. We'll record all that. Then you, like this clause number 6, is she aware of clause number 6? Ask her. You agreed for mutual consent divorce. And you will withdraw the RPFC also. We'll have this matter on day after tomorrow. By that time, give her a DD, not the check. This is matter day after tomorrow on the top of the list. On the top of the list at 10:30 we'll complete it.
Some corrections we need to
Like the parties are permitted to file a fresh compromise memo. You can take this, like they are permitted to make a fresh compromise memo. Instead of making all the corrections, file a fresh petition. Yes, with the signatures.
Direction to issue DD.
Get the DD, no check. The London Council for the petition seeks time to get the DD. List this matter list this matter day after tomorrow on the top of the list. Very soon. Other matters tomorrow. Let it repeat.
It is posted tomorrow. Instead of tomorrow minutes, it will be taken on day after tomorrow.
Signed.
That's the reason is tomorrow I am not available. I am going to bed. Day after tomorrow.
What is that?
With my lord's kind permission, serial number 93, there is interim order till today.
Because it's not reached. No,
On last occasion, it was not reached.
92 interim order earlier granted is extended till the next date of hearing.
93.
The order must have been like that till the next date of hearing.
Please,
So unless until it is heard whether reached or not, it will be there.
What?
Is it not? Yes, next. In?
There's interim order.
In which case?
94.
Not necessary, it is not heard. Till the next date of hearing, it was not heard. Not necessary, it will be there.
I have one submission, ma'am. 94, ma'am.
Yes.
My husband is going to file some document, just he copy to me. I have to verify my some instructions.
While the matter is in a final hearing stage, now we will give documents and the
If
court has
just is, sir.
Now it is learned that my lords,
Just now is, sir.
these are relevant documents, my lords. Now, yesterday we have obtained settlement copies. There is another parallel suit filed by other party, my
So
lords.
how can, in what form, the court will look into all those documents in a CRP in a final hearing?
This is only to show that, my lords, the respondent hearing was aware about the proceedings.
Order 41 or 27 will apply?
Only memo, I'll file order 41.
Not necessarily, let it be there.